A very good morning and welcome to the 19th meeting of the Criminal Justice Committee in 2025. We have apologies this morning from Fulton McGregor and we're joined in his place by Michael Matheson. So our first item of business is consideration of a negative statutory instrument, the Firefighters Pension Scheme Amendment Scotland Regulations of 2025. And I refer members to paper 1, which sets out the purpose of the instrument. So can I ask whether any members wish to make any recommendations in relation to this negative instrument? Otherwise, are we content that this comes into force? Content. Thank you very much. Okay, thank you. So we'll now have a brief suspension to allow the Cabinet Secretary and her officials to join us. Thank you. Okay, thank you, members. So our next item of business today is an oral evidence-taking session on an affirmative instrument, and that is the Home Detention Curfew Licence Amendment Scotland Order of 2025. So we're joined this morning by the Cabinet Secretary for Justice and Home Affairs, and I also welcome to the meeting Ruth Swanson, Solicitor, and Kevin Fulton, Community Justice Division at the Scottish Government. And I refer members to paper number 2. And I intend to allow up to 20 minutes for this evidence session. So can I invite the Cabinet Secretary to make some opening remarks on the SSI?
Good morning and thank you, Convener. To begin with, I would like to thank the Parliament Clerks, DPLR Committee and the Criminal Justice Committee for agreeing to accommodate the scrutiny of the SSI with the minimum SSI lane period of 40 days. I hope that committee and the wider Parliament will support these proposals, which will allow us to complete the SSI process before Parliament rises for summer recess. And this will provide the Scottish Prison Service and Justice Social Work staff with as much time as possible to make preparations before the proposed changes would come into force on the 20th of October. As members will be aware, the changes set out in this SSI were a commitment made in the programme for government for 24-25. They were included as part of our ongoing efforts to achieve an effective balance between the use of custody and the use of community alternatives and support our efforts to achieve a sustainable population across our prisons. Home detention curfew is a long-standing part of the prison system, consistently being deployed as a method of easing the transition from prison sentence back to the community. Home detention curfew provides a structured way to manage this transition, placing the individual under clear licence conditions and a nightly curfew, while allowing them to readjust to life in the community and to engage with any support that they need. The foundation of home detention curfew is the individualised risk assessment that is conducted by SPS with evidence provided by community-based justice social work staff before any individual is permitted release on home detention curfew. And I can assure members that these proposals put forward in this SSI will not alter any of the risk assessment aspects of the HDC process. The SSI proposes to allow home detention curfew to be granted from an earlier point in a prisoner's custodial sentence, from the current point of 25% of their sentence served in custody to 15%. This change will help realign the home detention curfew process with the new automatic release point for eligible short sentence prisoners at 40%. It will enable individuals to spend a similar proportion of their sentence on HDC as they would have previously done. The SSI includes a further proposed change to increase the maximum permitted period that an individual can be granted home detention curfew from 180 days to 210 days. This change will only affect a minority of prisoners where their sentence length and other circumstances make it possible for them to be granted a longer period of HDC. All eligible individuals will continue to have to pass the risk assessment and community assessment process before they would be granted home detention curfew. Home detention curfew will continue to be based around the same risk assessment of each eligible individual. It is therefore not expected that these changes in time criteria will produce a significant increase in the number of individuals being granted HDC. Instead, it will facilitate suitable individuals to be granted more time on HDC than they currently can be following the change in automatic release point. This is likely to result in more individuals being in home detention curfew at any one time. However, the numbers of prisoners who will access home detention curfew in the future will continue to be shaped by the number of eligible individuals in the prison population at any one time and how many of them pass the risk and community assessments. Overall, the proposed changes are relatively straightforward and are intended to enable individuals who are eligible and have been assessed as suitable to be granted more of the days on home detention curfew that they are eligible for. So on that basis, I would encourage members to indicate their support for the SSI, and as always, Convener, happy to answer any questions that members have.
Okay, thank you very much, Cabinet Secretary. So now we'll open up to members for questions, but I wonder if I can maybe just kick things off. Obviously, the SSI seeks to alter the timescales around eligibility for HDC, as you've stressed in your opening remarks. So that doesn't, just to confirm, that doesn't necessarily mean that they are in the process for HDC. It's just that they're eligible, and nothing in that regard changes by virtue of the timescales being altered.
So, as members will be aware from the policy memorandum, there are very clear statutory exclusions. Members will be familiar of what they are. So that means there's a cohort of people that just are not considered for HDC. Then there is other statutory criteria, all of which have to be met. So it has to be sentences of 3 months or more. People have to have served at least a proportion of their sentence, and that's one of the things that we are proposing to change. You can only be on HDC for a minimum of 14 days and a maximum period as well. So the criteria around sentence length, eligibility of proportion of sentence served, minimum and maximum period, they all have to be met. And the reality is, and I suppose if I give an example, if someone was sentenced to 1 year and the given that the automatic early release point has changed for some short-term prisoners. So before the changes, it would have been 180 days. For some people, it's now 144 days that people are released if they're serving a year. So that change, because of the changes to the short-term population, means that the potential time spent in HDC has reduced from 90 days to 54 days. So that's the potential time. So we want to realign the HDC process to the short-term prisoner 40 programme. But it does not mean that every prisoner eligible for home detention curfew will be eligible for the maximum time, because it depends on the length of their sentence. Also, how long they've spent on remand, and then, you know, how long the assessment process takes, how long it takes to gather information, particularly from the community. And, of course, people have to pass the assessments as well.
Thank you for that. And it was quite helpful to hear the example, which perhaps helps members sort of set it, the changes in their heads. OK, so I'll bring in Liam Kerr.
Thank you, Convener. Morning, Cabinet Secretary. What does the data show will be the impact on rehabilitation of this reduction? Because arguably, if there's less time in prison, there's less time for prison rehabilitation to work and prepare people for the outside. And the reason for me asking is one would hope that the data is robust, because otherwise this could look like just another way to empty the prisons and criminals serving ever shorter sentences at 15%.
So it is certainly not a way to empty our prisons, that's for sure. Perhaps if I can give an example. So, you know, at any given time, you have around 3,000 short-term prisoners. And yesterday there was 106 people on home detention curfew. So I hope that gives a sense of proportionality, that, you know, there is absolutely no automatic right, even when we change two of the criteria. You know, this is all subject to risk assessment. It's also important to say that home detention curfew has a high rate of successful completions. And in terms of rehabilitation, I think there's an important point that our prisons are for rehabilitation as well as punishment. So what happens in terms of that rehabilitative process within prison is important. But what home detention curfew does for some prisoners is it shifts the balance between time spent in custody and time spent sentenced in the community, bearing in mind that you are tagged, electronically monitored, and on a licence and on a nightly curfew. So home detention curfew is a restrictive way to ensure that people can be sentenced, spend part of their sentence in the community, and that also enables people to engage with support that they require in the community as well. And it is a managed process of reintegration, and the evidence shows us of the value of community-based approaches in comparison to time in custody. But I do stress that the completion rate, the successful completion rate of home detention curfew is very high.
I'm grateful for the answer, and I say this with great respect because I do enjoy our exchanges, Cabinet Secretary, but I'm not sure that answered my question, which was about the data, the research that has been done about what impact this will have on rehabilitation in prison. So if you have that, if you could outline that when you respond to this next question as well, which is that in your opening remarks, you said that there would be no change to the risk assessments. But if people are in and out of prison sooner, then logically it would be more difficult to risk assess them and also address any issues that they're bringing with them from the outside. So therefore, when you say that there will be no change to the risk assessments, has there been some investigation done as to whether there might be a need for a change to the risk assessments, or has it just been assumed?
So, in terms of Mr Kerr's first point, the successful completion rate of home detention curfew is, in terms of the latest figures available, is 93%. So that means there's a 7% recall rate. In terms of your point about if people have a very short time in custody, how does that support rehabilitative opportunities? But the reality is, while someone becomes eligible, currently at 25% as one of the eligibility criteria, and of course we're advocating that we change that eligibility. But just because someone becomes eligible at a point in their sentence, that does not mean that they will be released at that point, because they cannot be released until the risk assessment process is complete. And that is a significant process. So it would start with screening for eligibility. It's also important to say voluntary. Prisoners have to apply for this. They can't be made to go out on home detention curfew, and not every prisoner wants to be released on home detention curfew, which I think speaks to the restrictive nature of it, you know, licence tag curfew. The application for home detention curfew has to undergo a full risk assessment. I can talk you through that if need be, and there are practice standards for that. And if that risk assessment is positive, they will then, you know, contact Justice Social Work, who will be looking at suitability of address and speaking to the other individuals at the address. And so information from social work and police is important. And I suppose to get to the nub of Mr Kerr's question, that you cannot be released if you are not eligible and if you have not passed the risk assessment process.
Has there been any research or investigation done prior to laying this instrument as to the impact of reducing the time served to 15% on victims and or the general public's respect and perception of sentencing in Scotland if a criminal can be sentenced to prison but only serve 15% inside?
So, in terms of research, we know that home detention curfew is rooted, it's been with us a long time, for decades now. It is rooted in the Criminal Proceedings Scotland Act 1993. So as a concept for the justice agencies to work with and assess, it is well established. Obviously, it runs in parallel with the victim notification scheme, which I know this committee has taken a great interest in, and there are improvements to the victim notification scheme in and around the Victims Witness Justice Reform Bill. But in terms of specific research, in terms of this specific change, the answer is no. But this is to align ourselves to the position which we had before the changes to short-term prisoner automatic early release. So before the legislation that Parliament passed at the end of last year, we had around, on any given day, around 150 people on home detention curfew because of those changes, and particularly the transition period where there were people released in 3 tranches, the numbers reduced to between 70 and 80. As I say, they're now slowly increased. So this is essentially about a realignment to support to optimise HDC back to levels that it was prior to the changes in the automatic early release point for some short-term prisoners.
Finally, from me, you said, Cabinet Secretary, that there would be more people out on HDC, although not significantly more, to be fair. But logically, your 7% failure rate will increase if there are more people subject to the regime. Ultimately, it's for the SPS to consider breaches and whether or not to recall. What research has been done on the ability or the freedom of the SPS to make a decision given the context of full prisons? Does that stay their hand when deciding whether to recall people from HDC?
So, whether someone is recalled from HDC, it would have to be proportionate in relation to the breach of licence. So the condition, the decision is framed around whether or not somebody's breached their licence and the circumstances around that. And that is clear. It's while optimising the use of home detention curfew assists in the management of a very large prison population, it is also a reintegration tool, and it is certainly not the silver bullet for our large prison population. But if I can reassure Mr Kerr that in terms of the operational decisions that SPS make, the issue is around risk, the partnership work with communities and the information that they have around whether someone has breached their licence or not. And that is where the decision has to be made in terms of whether anybody is recalled. But if it's helpful, I could maybe ask Prison Service to give more information to committee on that point.
I'd be grateful. Thank you.
Thank you very much, Cabinet Secretary. Okay, so if we can move on, our next item of business is to consider a motion to approve the affirmative SSI on which we've just taken oral evidence. So can I invite the Cabinet Secretary to move motion S6M number 17635 in her name and make any brief additional comments that she wishes to make?
It moved, Convener.
Thank you very much. Does any other member wish to make a final comment? No? Thank you very much. So can I invite the Cabinet Secretary to wind up and press or withdraw the motion?
Press the motion, Convener.
Thank you very much. So the question is that motion 6SM number 17635, that the Criminal Justice Committee recommends that the Home Detention Curfew Amendment of Specified Time Periods Scotland Order 2025 be approved. Are we all agreed?
No.
No. Okay, we are not agreed, so we shall move to a vote. So all those wishing to vote in favour of the motion, please raise your hand. All those against, please raise your hand. Thank you. There are no abstentions. Thank you. So we have 6 votes for the motion, 2 votes against the motion. There are no abstentions. Therefore, the motion is agreed. So are members content to delegate responsibility to myself and the clerks to approve a short factual report to the Parliament on the affirmative instrument? Okay, thank you very much. This will be published shortly, so thank you very much, and we'll now take a short suspension to change over officials before we begin our next agenda item. Thank you. Okay, thank you very much. So our next item of business is Stage 2 of the Criminal Justice Modernisation and Abusive Domestic Behaviour Reviews Scotland Bill. So I would ask members to refer to their copy of the bill and to the marshalled list of amendments and groupings for this item. And if I can just ask members to note that a supplement to the marshalled list was issued yesterday, which contained an additional amendment, Amendment 93. So Amendment 93 was lodged as a manuscript amendment under Rule 9.10.6, and I decided that Amendment 93 may be moved at the Stage 2 proceedings. So Amendment 93 will be debated in the group entitled Use of Digital Productions, and will be called immediately after Amendment 46 and before Amendment 47. So I welcome Angela Constance, Cabinet Secretary for Justice and Home Affairs, and her officials to the meeting. And I also welcome other members of the Parliament to the meeting who are or will be here to speak to their amendments later on. So I will stop at an appropriate point this morning, obviously to allow a short comfort break in proceedings. And I don't want to curtail debate today on this important bill, but if I can ask members and the Cabinet Secretary to be as succinct as possible whilst making their points clear. So we'll now begin our consideration of amendments. So I call Amendment 56 in the name of Sharon Dowie, grouped with Amendment 57. Sharon Dowie to move Amendment 56 and speak to both amendments in the group.
Thank you. Move Amendment 56. And my Amendments 56 and 57 work together to clarify that where someone indicates that they wish to receive a paper copy of a document or does not express a willingness to receive it electronically, then it's available on request. The committee heard concerns throughout our evidence sessions in this bill about the ability of certain vulnerable individuals to read and sign electronic copies. Age Scotland told the committee in a written submission that more than a third of older people who have access to the internet lack the basic digital skills to use it effectively and safely. Older people in particular may not feel comfortable nor fully know how to navigate the system of electronic documents. Even if they received help or guidance in this, there is still a need to allow for access to physical documents. Victim Support Scotland welcomed the ability for individuals to choose. Age Scotland and Victim Support also made the point in their contributions to the committee about the need for reassurance that physical documents would still be available. The Cabinet Secretary has provided reassurance that the bill does not remove scope to communicate in the traditional way. However, my amendment clarifies this so that there is no confusion or misunderstandings, ensuring everyone retains access to physical documents upon request.
Okay, thank you very much. Do any other members wish to come in? No? Cabinet Secretary.
I understand Ms Dowie's intentions, but unfortunately I cannot support Amendments 56 and 57 for a number of reasons. Prior to the Coronavirus Scotland Act 2020, the transmission of legal documents took place by having the hard copy document physically couriered between parties or organisations or by personal service on individuals. Since the provisions relating to electronic transmissions were introduced in 2020, they have become firmly embedded in Scotland's justice system, modernising many justice processes and making them more efficient and cost-effective. Ms Dowie's amendments would make it a legal requirement to provide hard copies on request, which may not be possible in every circumstance. In particular, Amendment 56 does not specify who would be entitled to make such a request and who would be required to respond to it, which may impact on existing rules and policies about public access to case papers held by courts or by parties. I am concerned that Amendment 57 may impact on existing rules about how non-electronic service of documents works. The Criminal Procedure Scotland Act 1995 contains detailed rules about how non-electronic service of different types of documents on different recipients is to be carried out. Methods can range from postal service through to personal service by an officer of law, such as a constable, sheriff officer or prison officer, None of these are dependent on a request being made, and the methods generally involve delivering a document directly to a recipient, not making it available. It is unclear how Amendment 57 is intended to interact with these rules, and the consequences would need to be properly considered. The provisions in the bill already permit individuals to receive documents in hard copy. The provisions simply offer an additional option to those who wish to and are able to use electronic means. Whilst I cannot support these amendments in their current form, I would be happy to work with Ms Dowie in advance of Stage 3 to explore whether any provision is required to achieve her intentions here, whilst ensuring that no disruption is caused to operational practices that have now been in place for over 5 years, and in some situations longer. I know that the Crown Office and Procurator Fiscal Service and the Scottish Courts and Tribunal Service have indicated that they would be happy to be involved in this too. On this basis, I would ask that Ms Dowie does not press these amendments. Thank you.
Okay, thank you very much. Sharon Dowie to wind up and press or withdraw Amendment 56.
Thank you. Based on the comments from the Cabinet Secretary, I'll work on them for Stage 3 and I won't be moving. Thank you.
Okay, thank you very much. So the members indicated that they wish to withdraw the amendment. Does the committee have any objections? Okay, thank you very much. So I call Amendment 57 in the name of Sharon Dowie, already debated with Amendment 56. Sharon Dowie to move or not move?
Not moved.
Thank you. So the question is that Section 1 be agreed. Are we all agreed? Agreed. Thank you. So we now move on to the group entitled Virtual Attendance, Criteria for when virtual attendance applies. And I call Amendment 33 in the name of Pauline McNeill, grouped with Amendments 35, 36, 37, 38, 39 and 40. Pauline McNeill to move Amendment 33 and speak to all amendments in the group.
Thank you. Good morning. Can I begin by thanking the Cabinet Secretary and all her officials for what I thought was some really helpful exchanges over trying to understand some of the technicalities in the bill, so thanks for that. Some of these amendments I did draft before we had our last conversation, so I ask you to bear that in mind. I still wish to probe some of the important issues relating to how virtual attendance would be used in our courts. Similarly, I'd like to put on record that I'm fully supportive of the principle of virtual attendance being used in our courts as a permanent basis. I think it's important for the proper functioning of the courts, and as the Crown Office officials gave very good evidence to this committee, its importance in relation to victims who wouldn't otherwise come to court. But we obviously have, this Parliament, and through successive Parliaments, have put really, I think, excellent framework legislation in for vulnerable witnesses, so it doesn't stand alone. Amendments 33, 35, 36, 37, 39 and 40 would mean that the Lord Justice General has the power to issue a determination to change default mode of attendance to virtual attendances in certain circumstances, but not for certain types of cases. So, I confess that reading the bill, it wasn't too clear to me what the difference between, well, I think the difference between cases and types of trials, for example, or types of proceedings would mean that virtual attendance would be for individuals and cases. Now, we already know that the Lord Justice General hasn't exercised this power, has been used quite sparingly. So that's noted. But I think what the committee may be satisfied if we grant quite an extensive power, it could be used much more regularly. But the default mode of attendance to virtual for certain types of hearings already includes preliminary hearings, some sentencing hearings, full committal hearings and bail appeal hearings. So I have no particular concern about any of that because that's kind of sort of administrative in some senses. It doesn't really involve witnesses, although I do want to comment on the issue about custody appearances, and that's just concerns that have been raised by the Bar Association. So what I'd just like to be clear about is that the Lord Justice General, who has used the current powers for these hearings, couldn't, for example, say a category of trials would be virtual. I don't think it does that. You're already shaking your head. But I just wanted to be sure where these powers stop and start. So that's what I'm intending to do here. Amendment 38 prescribes that for virtual attendance is to be agreed, it must have the approval of both parties, the accused and the complainer. I think it's probably already accounted for. I think you're going to say to me that it's when it's in the interest of justice to do so is the test. Fair enough. But I hope you appreciate what I'm tasting at this point is the hearings that already are used for and where the line is drawn. I mean, the committee itself did say that it would highlight is the criteria should be used by the Lord Justice General making a determination in favour of virtual attendance in particular categories or cases. The bill doesn't elaborate on what criteria should be beyond that it should not prejudice the fairness of proceedings or contrary to the interests of justice. And in the view of the committee, we thought there should be additional criteria that the Lord Justice General must take into account before making a determination. So I think it's just belt and braces really on that. Just lastly, on the custody courts, you'll know that in evidence the committee did hear, there was a question that started with Sharon Dowie on the case for custody appearances to be virtual, and we've heard from Paul Smith and Simon Brown, and their concerns, I think, are really around just being able to, I suppose, ensure that there's proper coordination between the person they're representing and the virtual attendants. They've also raised issues about the quality of connection, which I have. I won't go through it again. I've seen it for myself. So, and I thought it would be kind of a prerequisite to ensure that if we're going to rely much more on virtual attendance in courts, we're clear about where it can be used. And lastly, that it's as good as it can be in terms of, and it does not detract from current arrangements, particularly as Paul Smith says in his evidence, where an accused person has never been through the court process before. I don't think it would be fair to prejudice their interests. So I think it's really important that we're all clear that that's all brought together and is satisfactory. Thank you, Convener.
Does any other member wish to come in? No? Okay, Cabinet Secretary.
Thank you. Convener, the bill provides for virtual attendance in criminal proceedings by making permanent the legislative underpinning that has been in place since 2020. The framework for virtual attendance is admittedly somewhat complex, which is inevitable given it must account for the complexity and range of scenarios that arise day to day in the criminal justice system. The amendments in this group, I'm afraid, unpick that framework and shift the balance away from individual decision-making on a case-by-case basis to one in which there is less flexibility and a greater role for blanket determinations and decision-making and powers of veto. And I appreciate that that may not have been Ms McNeill's intention, but I'm sure Ms McNeill and committee will understand I have to respond to the effect of the amendments according to their terms and the operational impact that they would have. These amendments would erode and, in some cases, eliminate the ability of our courts to consider the full range of facts and circumstances of the cases they hear in making decisions on virtual attendance. So I therefore cannot support any of the amendments in this group. Under the bill, it is the default position that people attend court in person. In individual cases, the court can opt to disapply this default and direct individuals to attend court by virtual means after taking into account what is in the interests of justice and any representations received from the parties. The exception to this is proceedings where the only party is a public official, such as police officers or prosecutors seeking warrants or court orders, where the default position is virtual attendance. Again, the court can disapply this default on a case-by-case basis and require physical attendance. The bill gives the Lord Justice General the power to issue determinations to disapply the default for physical attendance in certain types of cases and in certain circumstances. There is currently an important limitation on that power, being that the Lord Justice General cannot issue determinations in relation to trials or for hearings at which the only party is a public official. Amendments 33, 35 and 40 would remove that limitation and expand the scope of the Lord Justice General's power to make determinations to any form of criminal proceedings. This would give the Lord Justice General the power to effectively set virtual attendance as the default for criminal trials, should he choose to do that. And this is a substantial expansion of the power and a significant departure from the current approach. And I do not believe that the committee heard any evidence at stage 1 that would support such a change, nor did it make such a recommendation in its report. I have also not heard any support for the amendments which relate to guidance issued by the Lord Justice General. Amendment 37 requires courts to comply with such guidance rather than have regard to. Amendment 39 requires that the guidance must set out when virtual attendance must always apply and when it must never apply. These amendments again represent a departure from recognising that the courts will need to consider cases and circumstances on an individual basis to balance all relevant interests, and after taking into account such information, it should be ultimately for a court to decide how individuals should appear before it at trial. Amendments 36 and 38 further erode the court's flexibility. Amendment 36 would in some circumstances create further procedure overall, where there had been a change in circumstances between pre-trial hearing and the trial, and a witness now required to give evidence remotely. This amendment would mean that an additional hearing would have to be convened to allow parties to be heard in the matter. The existing drafting of the bill is more efficient and would give the court the ability to make a decision which the other party could object to at trial if they so desired. In relation to Amendment 30, I do not agree that it is appropriate for complainers or the accused to be able to unilaterally veto the virtual attendance of anyone else, for example, a police witness or a forensic scientist. These are properly decisions of the court which will balance the interests of those involved and is required by the bill to hear representations from the parties and consider whether the direction would prejudice fairness or otherwise be contrary to the interests of justice. Convener, taken together, the amendments in this group would lead to a more prescriptive framework that would restrict the court's ability to be agile and responsive and to take into account individual circumstances and make informed decisions when determining how individuals appear at court. And for that reason, I cannot support any of the amendments in this group. And as Ms McNeill and colleagues will recall, virtual custody court provisions have been paused until the issues are fully resolved.
Thank you very much, Cabinet Secretary. So, Pauline McNeill to wind up and press or withdraw Amendment 33.
Thank you very much, Convener. First of all, I'll begin with, I'm broadly content with what the Cabinet Secretary has said, but I'd like to put on the record that what I'd asked to be drafted was in relation to the clarity I wanted around what powers or how the powers by the Lord Justice General could be used in relation to, if you like, the separation between hearings and trials. Because when I read the bill and the explanatory notes and the policy memorandum, I couldn't see it clearly written that that was the division, but I think that's what you've said, and I am content with that because I don't support it. So that is what I'd asked to be drafted, but what's come out is, I would accept, it's not quite what I had intended. I'll finish with this. So I note that the biggest concern raised by the committee, I hope would be acknowledged by the Cabinet Secretary, was from defence lawyers about, I don't know if it was the principle of custody courts, but some of the practicalities, which is why it's been paused. So I would like to come back at stage 3 or have a discussion, because I wouldn't want to just let go of that, pass the bill, whilst this is still ongoing and unresolved, because it's so, we were granting powers, which once we've done so, there isn't really any sort of comeback, so to speak, for if we get this wrong. So on that basis, Convener, when you ask me, I will not be moving and I'll withdraw my first one.
Thank you very much indeed. So the members indicated that they wish to withdraw Amendment 33. Does the committee have any objection? Okay, thank you very much. So we now move on to virtual attendance requirements for attending virtually. And I call Amendment 34 in the name of Pauline McNeill, grouped with Amendments 41, 42 and 43. Pauline McNeill to move Amendment 34 and speak to all amendments in the group.
Thank you very much. Amendments 34 and 42 prescribe whether a location would be deemed suitable for a location for remote attendance, which specifies that the location must have a court official in attendance and an adequate speed of connection. I've mentioned before my experience, particularly in relation to the connection issue, which has been raised by all the witnesses. There is an issue which I'm sure will be addressed by the government, which is to ensure that there's equality in how people are able to attend virtually. That's the older people, for example. We heard H Scotland might struggle with getting online, so there's considerations to be thought about in relation to certain groups of people. I mean, it may well be that the Cabinet Secretary is content that the bill sets out clear criteria for how evidence should be given and where it should be given. As previously mentioned, I mean, the evidence given by a commission has been a great success, and I've seen the facilities for myself, and I would thought that would be the standard. I mean, when I was discussing it with the legislation team, I just wanted to prescribe some things that would make sense to, because I think maybe they're the wrong ones, but I wouldn't be content just to say that there'd be any circumstances you could give evidence anywhere. I think it is a court of law, and giving evidence virtually must have some requirements. I would have thought that everyone's content with that it has an equivalency to a courtroom. And that's all really I'm trying to achieve with these amendments. Thank you.
To speak to Amendment 41 and other amendments in the group.
Yes, thank you, Convener, and good morning, Cabinet Secretary. Both my Amendment 41 and 43 are relevant to Section 2, which deals with the virtual attendance at court. When we look at what Section 2 does, we need to ask if, as drafted, all necessary matters have been covered. And if we look at page 6 of the draft bill, the new Section 303K addresses the ability to attend by electronic means. Now, that section goes on to state that someone excused from a requirement to physically attend court must do so by electronic means in accordance with a direction issued by the court. And subsection 3 then talks about what that direction needs to look like. So my Amendment 41 simply asks that that direction include to set out the location of where the person is to appear by electronic means. And that reflects concerns raised in the committee's report, which said, we recommend that the bill is amended to include an additional requirement for the court to issue a direction in relation to the appropriateness of the location from which an individual participates to address the concerns highlighted in evidence. It is, of course, entirely at the court's discretion to determine what and where that location might be, and they would naturally take into account all the facts of the case. On a practical level, presumably that would only be done after consultation with the person concerned about the appropriateness of the locations available to them. Now, Amendment 43 stays with Section 2 and the virtual attendance. Virtual attendance, I think, will be a pretty new concept to us. And so the question is, will it work? I think it will. But there is a much remarked on dearth of data and outputs in this Parliament generally. And I seek in my Amendment 43 to remedy that, at least at this level, because I'm inserting a new clause after the Section 2 to require a report including various specifics around reliability and resourcing on how the virtual attendance section is working And I would like that report no later than 2 years after this Section 2 comes into force. And again, this is in line with concerns raised by witnesses to the committee about virtual appearances being dependent on proper resourcing and current issues with technology. So I remind the committee that the Sheriff Principal told us we would observe that virtual hearings are heavily dependent on the adequate resourcing of technology and infrastructure. And the Faculty of Advocates told us these undoubted and important benefits do come at a cost to the justice system. Valuable court time is regularly lost due to delays in establishing remote links and re-establishing failed remote links. This is also in line with a letter that I've received from the Chief Executive of the Scottish Courts and Tribunal Service, which I can make available to anyone who requests it. I raised questions about the operation of virtual courts, and the letter in response conceded that, and I'm quoting, SCTS does receive feedback that live links are not always as effective as they could be. Hence, my Amendment 43 looks to have a report on what's actually happening once this is brought in. Just for completeness, I listened carefully to Pauline McNeill's representations earlier on. On Pauline McNeill's Amendment 34, I don't entirely understand how the costs and logistics might work if this amendment goes through. So I'll listen carefully to Pauline McNeill's closing, but at this stage I'm not persuaded by this amendment. Similarly, I'm not persuaded by Pauline McNeill's Amendment 37, as I worry about fettering the court's discretion and ability to manoeuvre. But again, I'll listen very carefully in her closing. So with that, Convener, I move Amendment 41 in my name.
Thank you very much. If no other member wishes to come in, Cabinet Secretary.
Thank you, Convener. The requirements for virtual attendance was a very clear focus of the committee throughout Stage 1. However, it should be acknowledged that forms of virtual attendance have been practice in our courts for decades now. Vulnerable witnesses have routinely given evidence remotely, and pre-pandemic it was possible for an accused person to be sentenced via video link from prison. There are a number of benefits to allowing more witnesses to give evidence remotely. It reduces travel time and costs and reduces disruption for witnesses, making our justice system more accessible and responsive to the needs of all its users. Ms McNeill's Amendment 34 would therefore be a step in the wrong direction, requiring a court official to be in attendance with any person attending a trial virtually is wholly unworkable in practice and would place an unsustainable burden on court officers, leading to unquantifiable but very significant costs. The use of virtual attendance for police and professional witnesses giving evidence in high court cases is currently the norm. This allows police and doctors in the NHS to be removed from their frontline duties for less time. In his submissions in January, Malcolm Graham of the Scottish Courts and Tribunal Service confirmed that since January 2022, more than 950 police officers and more than 370 expert witnesses have provided evidence remotely to the High Court of Judiciary, of course.
I don't have experience. I've only seen where people give evidence in the victim support headquarters, which are very impressive, as I said. What's your understanding of who then checks in when someone's giving evidence from whatever location, that things like, I presume they still have to take the oath and all that kind of thing, and I think we all agree that there shouldn't be anyone else in the room that might interfere and all of that. So who checks that then? Yeah. Is there a way of doing that? I mean, I totally acknowledge that it's maybe not practical to a court official. I concede that to Liam Kerr and to yourself, but I suppose what I was trying to get at is, well, surely there should be some checks and balances. Otherwise, you're going to have people giving evidence, if it's not from Victim Support's lovely, well-established offices, in a location, who's going to check that it's got the same conditions as giving evidence in court? But that's just my lack of understanding. Yeah, no, and I understand the point that Ms McNeill has been making. But I suppose if I go back to Stage 1 and the evidence given by the Crown Office,
and they emphasised that their expectations for vulnerable and also non-vulnerable civilian witnesses, that when attending remotely, that they will do so either from a Scottish Courts and Tribunal System remote site or another designated site, whether that's, maybe a VSS facility or a designated site such as a Bairns House, and the Crown Office have confirmed that this remains their position. And I know Ms McNeill didn't quite ask this, but just to say, witnesses are not routinely given evidence from their homes. In fact, that's exceptionally rare, and I've been told vanishingly rare. And I mean, that would be where perhaps a witness has a medical condition, perhaps agoraphobia, or they're medically unfit. And before the emergency legislation, there was always scope to make an application to the court to enable such an arrangement if that was crucial. But the court would have to specifically sanction any such arrangement. So that was the case previously, and it remains the case under the emergency legislation and the bill. Ms McNeill has spoken about that we continue to invest in the evidence by Commissioner suites for pre-recorded evidence, and she is correct about that witnesses still have to take an oath, and that there is guidance that is sent to witnesses from the Crown Office, and that is about making sure that people understand the solemnity of the proceedings, and it's actually quite detailed. It's, I don't want to read all the extracts from the guidance convener, but I can perhaps make sure that committee receive it. But it's things like the Procurator Fiscal will inform the witness via telephone when it's their time to join. There's very clear expectations that people need to be heard, and they need to be able to see proceedings as well. Of course.
Thank you, Convener. Thank you, Cabinet Secretary. Just building on the response there, I wondered if you would be able to clarify if and what engagement the government has had with the courts between stage 1 and stage 2 today on these points.
So, as you would expect, Mr Macpherson, Convener, that our contact with the court service is, of course, ongoing, and particularly in terms of us understanding in more detail the operational aspects that politicians and civil servants aren't working with on a day-to-day basis. But in and around the information that is provided to witnesses, perhaps I could remind members that the bill already provides that when a witness is given evidence remotely, that there is a direction that will set out, how that witness will attend, and will provide for the witness to use electronic means that will enable them to both be seen, heard by all parties, the judge, and where applicable, the jury. And there's also information sent out about how to join the platform WebEx. Guidance looks quite clear to me. I'm not the most electronically able person, but again, we can ensure that committee, receives copies of the guidance that's sent to people in terms of the guidance around the witness protocol, if that would be helpful. But before signing into the WebEx, there are certain things that witnesses must make sure of, and again, I'm not going to read it all out, but I'll send that to members if that's helpful.
Yes, please.
Sure.
Not unless the convener wants me to go through it.
Okay.
Thank you.
Okay.
Okay.
Thank you.
Convener, in every circumstance where it is used, remote evidence is delivered in a way that is consistent with the solemnity and integrity of court proceedings. As the Crown Office set out in its evidence, professional witnesses, as I've said, are sent additional information on what is expected of them if they're cited to attend a trial virtually. The Scottish Courts and Tribunal Service, the Crown Office and the Faculty of Advocates and the Law Society of Scotland have also agreed a witness protocol setting rules that must be complied with by all witnesses giving evidence remotely, and I've already referred to that. This includes that while a witness is given evidence, no one else can be in the same room or be able to overhear what has been said unless the court gives express permission. When hearing remote evidence, the court also has all its normal powers to regulate proceedings, either of its own accord or in response to an objection raised by parties. As such, if there was concern that the integrity of proceedings was compromised as the witness is not complying with those rules, the court would be able to address this appropriately. Ms McNeill has previously probed the lack of a requirement in the bill for a witness to attend at Scottish Courts and Tribunal sites or other approved place to give remote evidence. Again, I would refer to the evidence of the Crown Office, which was supportive of the flexibility that could be afforded to police and professional witnesses, and highlighted that the framework of special measures to support vulnerable witnesses to give their evidence remains in place. Victim Support Scotland also highlighted in their Stage 2 briefing opposing this amendment. Witnesses can and do continue to give their evidence remotely using the court and tribunal system, remote sites and other purpose-built facilities, as I've mentioned. So therefore, I do not share Ms McNeill's concerns and would, with respect, ask her not to press her amendments. On Amendments 41 and 42, my officials have engaged with justice agencies on these, and on 41, committee members will again note the briefing from Victim Support Scotland cautioning against such an approach and opposing the amendment. On Amendment 41, there are a number of concerns. Again, as noted by Victim Support Scotland, there may be significant confidentiality and security concerns for some witnesses in having their addresses made available. There are also concerns that at the time the direction is made, which is often far in advance of trial, prosecutors may not know the location that remote evidence will be taken from, such as where it is subject to witnesses' working arrangements. As such, extra time and procedure would routinely be required to vary directions where closer to the trial date the location changes. There is a further concern that by being restrictive on location, this would limit the ability of the witness to be responsive to pressures arising where those matters may lead them to be working from a location which is not their usual place of work. On Amendment 42, it is not clear how these requirements could be enforced other than by the court reacting if there were real difficulties with the evidence being given. The court would already be able to respond to this appropriately, so I would be quite wary of placing an additional onerous and potentially impracticable obligation on the Scottish Courts and Tribunal Service. I also note that the bill already provides at subsection 3 of the proposed new section 303K that the court must set out in its direction enabling a person to attend virtually how they ought to do that. In practice, this is achieved by providing them with information on how to use the WebEx platform. The guidance is publicly available, and as I mentioned earlier, Convener, I can send it on. As with in-person attendance, issues in individual cases will no doubt crop up from time to time. However, I am satisfied that over the last 5 years of the operation of these provisions, partners have refined the process and have no concerns over implementation when it comes to remote evidence. As with any aspect of operational practice, they will continue to keep matters under review. And I do acknowledge that with virtual custodies, things have not been as smooth, and that is why those are paused to allow the development of an improved model that will better meet the needs of all users. In relation to Mr Kerr's Amendment 43, I do not think it would be possible, as currently drafted, to deliver the required report. information on technical issues is not collected and reported on in a systemic way, and to require this in relation to everything which might be considered a technical issue, it would be resource intensive. However, if the report were to focus on improving understanding of how virtual attendance is delivering greater efficiency and effectiveness, and was more closely linked to existing data collection processes, it may be that there is something that we could explore further, or if Mr Kerr's concerns relate to virtual custodies, then that will be addressed by the work being led by Malcolm Graham of the Scottish Courts and Tribunal Service. But of course, I would be happy to engage further with Mr Kerr on that in advance of stage 3. And to conclude, I would ask that Mr Kerr and Ms McNeill do not press their amendments in this group.
Okay, thank you very much, Cabinet Secretary. So Pauline McNeill to wind up and press or withdraw Amendment 34.
Thank you very much. Helpful exchange. Just to put on the record, I hope that my intention is not to be misunderstood here. I do support the use of virtual attendance, and the Cabinet Secretary has clarified the locations will have the solemnity, etc., which I think is important, because I don't think the committee should settle for anything less in extending or putting this as a permanent feature of the Scottish criminal justice system. We've got to ensure that it is done to everyone's satisfaction, but we all recognise it can reduce delays and it can make it easier for victims. So, in relation to locations, I'd just also like to say it wasn't me who brought this up. It was the Law Society and the Scottish Criminal Bar Association who did raised concerns about people giving evidence from home, and it was mentioned by another witness, which is why I addressed it. And I share their concerns, although I think the Cabinet Secretary makes a very important point here, which is, and I think this is a distinction to be drawn, that perhaps someone has a specific reason for that, then I think that's okay. But I am not in favour of people giving evidence at home for convenience, because I do not believe that the test would be satisfied. And I would prefer if we nailed that down at stage 3 so that it's clear in the legislation, because it's silent as far as I can see. I think it's important that we future-proof this legislation as well, thinking about because if we do improve connection, presumably it might be used a bit more. So I think we've just got to be clear when it can be used in the interest of justice and all of that. And yes, I do accept what the Cabinet Secretary said for public officials. I think it's a vitally important component. Although with police evidence would surprise me a little bit, because they have concerns about giving evidence virtually. I think it's for connection reasons, once again. Just lastly, I am not on Liam Kerr's amendments, not to speak for him, but I didn't comment. But on Amendment 41, I'm not too clear about why, in all circumstances, that I can see some circumstances why he wouldn't publish the location, or you could check the location for reasons that we've already discussed. I'm not too clear, because if you give evidence in court, then you give evidence in court in a known court with a known address. But and also, I do support what Liam Kerr said about Amendment 43, which is, I think we've got to get more. If there's a report, we've got to get more than just data. I mean, we do have, some reservations about whether virtual attendance is all it's, said to be. So I hope the government might consider what might give us the kind of report that would actually mean something, given the substantive change, permanent, because I have to say, we did what we needed to do during the pandemic. It should not be an argument to continue something that we did as a necessity to get through trials. So I just hope before we close the door on this at stage 3, the government will give more thought to that. But on that basis, I'll not be moving. Of course, yes.
Just to put on record, two things, and forgive me if I'm repeating myself, convener, but in terms of what Ms McNeill has said in and around people giving evidence at home, and I appreciate that she was articulating evidence given by others. But according to our justice partners, giving evidence from home is not the norm, and it's been described to me as vanishingly rare. But where the legislation already exists, it existed prior to this bill, and indeed prior to the COVID legislation. And the legislation, to summarise, is that it remains under the control of the court whether evidence can be given at home. But again, I'd be happy to write to committee to lay that out further. And I think the point I was trying to make in relation to Mr Kerr's Amendment 43, I think was much more, and I think it resonates with the point made by Ms McNeill that, that I wasn't closing the door on it, but actually I wanted a reporting condition that's actually more meaningful and more rounded in terms of giving information that means something in terms of how we scrutinise but also deliver greater efficiency and effectiveness. And I think that is broader. Data is important, but I do think it is broader than that. We sometimes go on a quest to gather more and more data as opposed to looking at existing data and how that could be better joined up and how it could speak to each other.
One, thank you for that clarity. I was not aware that legislation existed prior to the pandemic, so it's useful to know that. It's fair enough. But I would still say that, given that the purpose of the bill is for modernisation, to make these things permanent, you've got to envisage that there might be greater use of it, and therefore the bill is silent on when it can be used. That's what we're here to do, is to, when we're legislating, is to correct anything that may not have been right in the first place, and that is just to maybe just be satisfied that the requirements that for the conditions at which that would be allowed are clear to Parliament before we say that that is something which is in this legislation as a way of modernising and making the court system better. But thank you, Convener.
Okay, thank you. So just to confirm, the member wishes to withdraw Amendment 34?
Yes, please.
Okay, thank you.
I
So
seek to withdraw.
the member has indicated they wish to withdraw Amendment 34. Does any member object? No? Okay, thank you. So I call Amendment 35 in the name of Pauline McNeill, already debated with Amendment 33. Pauline McNeill, to move or not move?
Not moved.
Okay. I call Amendment 36 in the name of Pauline McNeill, already debated with Amendment 33. Pauline McNeill, to move or not move?
Not moved.
I call Amendment 37 in the name of Pauline McNeill, already debated with Amendment 33. Pauline McNeill, to move or not move?
Not moved.
I call Amendment 38 in the name of Pauline McNeill, already debated with Amendment 33. Pauline McNeill, to move or not move?
Not moved.
And I call Amendment 39 in the name of Pauline McNeill, already debated with Amendment 33. Pauline McNeill, to move or not move?
Not moved.
And I call Amendment 40 in the name of Pauline McNeill, already debated with Amendment 33. Pauline McNeill, to move or not move?
Not moved.
I call Amendment 41 in the name of Liam Kerr, already debated with Amendment 34. Liam Kerr, to move or not move?
Not moved.
Okay. I call Amendment 42 in the name of Pauline McNeill, already debated with Amendment 34. Pauline McNeill, to move or not move?
Not moved.
Okay, thank you. So the question is that Section 2 be agreed. Are we all agreed? Agreed. Thank you. So I call Amendment 43 in the name of Liam Kerr, already debated with Amendment 34. Liam Kerr, to move or not move?
Not moved.
So the question is that Section 3 be agreed. Are we all agreed? Agreed. Thank you. Thank you. So we now move on to their next group, which is use of digital productions. And I call Amendment 44 in the name of Liam Kerr, grouped with amendments as shown in the groupings. Liam Kerr, to move Amendment 44 and speak to all amendments in the group. Liam Kerr.
Thank you, Convener. And I'll speak to Amendment 44 and then specifically 45 and 46 at this stage, which relate to Section 4, which is on page 8 of the draft bill and is about digital productions. Taken together, these amendments are aimed at ensuring that whilst digital productions are possible, all parties have the right to view the physical evidence and that physical evidence can be produced. Taken individually, Amendment 44 deletes subsection 2 in the draft bill. And the reason for that is that subsection 2 refers to section 68 of the Criminal Procedure Scotland Act of 1995. Now, 68(2) of that Act provides that the accused is entitled to see the physical productions in specific places depending on which court the trial diet is happening. Section 4(2) of this draft bill changes the default position such that the accused would no longer be able to see the production physically if it is available in electronic form and the accused has had the opportunity to see it in electronic form. Now, I don't quite understand that because it feels like it's removing rights for no discernible benefit. So my Amendment 44 removes that new Section 4(2) in the draft bill such that the default position continues to apply and the accused can see the physical production on request. Now, moving to Amendment 45, the bill currently provides at Section 4, subsection 4, that images of physical evidence are to be treated for evidential purposes as if it were the physical evidence. Now, again, I'm not sure that we should be putting handcuffs on the court, and the process is it follows. So my Amendment 45 simply winds back from the absolute such that the image may be treated as if it were the physical evidence if the court wants to do so. Thus, it gives the court a more proactive discretion over whether this should be done rather than accepting it as the default. And finally, my Amendment 46 builds on that principle to provide that where the court has directed the image of the physical evidence be treated as if it were the physical evidence, then all parties and the judge may still request to see the physical item. My authority for these amendments is once again the committee's report, which says at page 20, at any point up to and including during a trial, any party, including the judge, who wished to see the physical production should not be prevented by this bill. We recommend that the Scottish Government strengthens these provisions on the face of the bill to make it clearer that this would be the case. And that was in line with the faculty of advocates who said in the call for views, in some cases the item may have certain distinctive physical characteristics which are less obvious in an image. This may be of particular importance in determining whether the item can be seen in CCTV footage. There may be limited occasions when this is the case. However, on such occasions, the items themselves may provide decisive evidence to incriminate or exculpate an accused. It's important, if the court is not satisfied by the use of an image in place of the physical evidence, that it remains open to the court to otherwise direct that the original item be produced. And that is what I've sought to capture in my first three amendments. Finally, from me in this group, the Amendment 49 is slightly different, but remains in use of digital production section. This amendment was suggested to me by the Law Society, which I remind colleagues that I am a member of and am regulated by. My amendment simply says that even though there is now a valid image of the physical evidence, that the actual physical evidence may not be destroyed whilst proceedings are ongoing, and that includes until after any appeal is completely finished. Now, again, this is in line with the committee's report, which says it is not clear how long that object must be retained for beyond that point. The concern from some organisations was that, in the absence of any guidance to the contrary, the existence of a digital image might make it more likely that the original physical object would be disposed of. This clearly would be inappropriate if there was a chance that the object may be required in any future court proceedings. So that was the reason for my submitting Amendment 49. I think it's important, Pauline McNeill submitted a very similar amendment at 48, which is very helpful, but goes beyond what I'm proposing. I'm not persuaded, Pauline McNeill, by Amendment 48 at this stage, because in taking it further, the reference to the SCCRC is that what we know is that the SCCRC can accept a request to investigate at any time, potentially years after the conviction, such that if Amendment 48 were to be accepted, presumably the original productions would always need to be retained, perhaps in perpetuity, undermining the point of the proposal. So I remain to be persuaded by Pauline McNeill's remarks on Amendment 48, but that's certainly my starting position, that it might go too far and undermine the proposal. And with that, Convener, I move Amendment 44 in my name.
Thank you very much. So, Cabinet Secretary, to speak to Amendment 1 and other amendments in the group.
Thanks, Convener, and apologies, this is quite a long speaking note. I will first speak to Amendments 44, 45 and 46 lodged by Mr Kerr and Amendment 93 from Ms McNeill. Amendment 44 would not be compatible with the rollout of the digital evidence sharing capability known as DESK, where electronic evidence is stored on DESK as opposed to on a tape or disc. There will be nothing that can be physically lodged, and the list of productions will simply note that the item in question is a digital production. Given this amendment would require the lodging of a physical item, it would not permit the use of DESK to store and share digital evidence in court. Amendment 45 would have the effect of making the use of physical productions the continued default. This would also significantly inhibit the rollout of DESK and require substantial amounts of court time and resource to be taken up with applications to allow images to be used. Amendment 46 is unnecessary and would serve no practical purpose. The ability for both the defence and the prosecution to apply for a judicial direction where they consider the image to be insufficient already provides a mechanism to deal with these issues clearly and promptly. Of course.
Just on that, and forgive me, Cabinet Secretary, as I just order my thoughts, but on Amendment 44 and 45, I heard that these amendments wouldn't work because of the progress that is being made on DESK, which the committee heard about and I think was very positive about. But just on a legislative level, should the law be led by what is happening in practice, or should the law seek to lead such that the practice follows?
Well, that will be for legislators. That will be for you and I. I mean, I'm not going to make a blanket determination on that.
Well, forgive me. I'm just worried that what the Cabinet Secretary appears to be rejecting my amendment because of something that's happening in practice, whereas I'm saying actually best practice is what I'm seeking to do to the legislation. And so actually, isn't it for practice to follow what the legislators have decided is the way forward?
So I would consider best practice to be aligned to modernising our criminal justice system so that evidence, in the example of DESK, the evidence can be shared from crime scene to courtroom, and that supports the overall efficiency and effectiveness and is to the benefits of everybody who comes into contact with the justice system. DESK has also been a programme of work that has benefited from £33 million of investment and has the support of our justice partners. So you will, I hope, understand my reticence of rolling back on the use of DESK, and I think it is right and proper that I, with respect, point out that Amendment 44 would not permit the use of DESK to store and share digital evidence in court, which was one of the main benefits of this significant programme of reform. Convener, in terms of my comments around Amendment 46, this also applies to Amendment 93 from Ms McNeill. The bill and my Amendment 5, which I will come on to, clearly set out the process by which parties can apply for a judicial direction to have the physical item produced. Amendment 93 would give parties an unqualified right to have items produced when they request it, with no role for the court to decide if that was necessary to avoid prejudicing the fairness of proceedings. However, I would like to take this opportunity to reassure Mr Kerr and Ms McNeill that there is an existing common law right for the defence to examine any physical item whose condition is critical to the case against the accused, even where it will not be produced at trial. There is nothing in the bill which interferes with this right, which will continue to apply even when an image is used at trial. That right should be exercised promptly after the defence are made aware of the item through disclosure by the Crown, and should inform any application to require the physical item itself to be produced in court instead of the proposed image. Of course.
So that's useful to know that there is a common law provision to allow parties to examine it. But I think that what myself and I think Liam Kerr are driving at here, well, this is what I'll speak to, but I do think surely in the interest of justice, it should be an unqualified right if you think it's in the interest of justice for the jury to see the weapon, or in the case that it is a weapon. There's a difference between examining something and that going before the court, surely.
So I think I will address, in my view, most of those points as I proceed. And if I don't, Ms McNeill, I'm sure, will intervene and me again. If convener, I can turn to Amendment 49 lodged by Mr Kerr and Amendments 47 and 48 lodged by Ms McNeill, which set out new requirements for the retention of physical productions. The aim of this bill has always been about using digital transformation to protect the rights of victims, witnesses and the accused, while supporting justice partners in modernising their operational practices, including those around retention. As I've already mentioned, common law already provides the defence the right to examine any physical item whose condition is critical to the case against the accused, and our provisions don't interfere with that right. Prosecutors have always been able to determine which productions need to be retained and for how long. There are obviously fundamentally different factors to take into account in relation to, for example, marijuana plants relating to drug offences, personal items belonging to victims and witnesses, and alleged murder weapons. And the bill does not alter the nature of these operational decisions. We sought feedback from justice partners on how these amendments would impact them. During stage 1, they had already expressed to the committee their concerns about retaining physical productions for lengthy periods, and justice partners have confirmed that these amendments would be financially devastating. It is already common practice for some evidence to be returned prior to the conclusion of a trial, which these amendments would prevent. For example, in instances where vehicles are involved in an accident and where a photograph was taken of the damage, the vehicle would need to be retained. Similarly, at present, where evidence is the property of victims or witnesses, the items tend to be returned with a label or image used in their place in the proceedings. Under these amendments, these victims would not have their property returned until a considerable time after the case had concluded. And in the case of the reference to the Scottish Criminal Cases Review Commission, it is difficult to see how the items could ever be returned. This is clearly inappropriate for personal items, and we know the distress even limited retention can already cause, for example, in relation to mobile phones. These amendments would also have the strange effect that in cases where images of physical production are used, the physical evidence will need to be retained for much longer than if the physical evidence itself had been produced. Overall, these amendments would have a very significant resource implication for justice partners who will have to store these items for longer, perhaps indefinitely, and represent a regressive approach to retention, which would have a distressing implications for many victims when applied to personal items. And I would therefore ask Mr Kerr and Ms McNeill not to progress their amendments. Turning to my own amendments, during stage 1, the committee heard a range of views on the use of digital productions and the need to protect the rights of all parties during a trial, whilst ensuring that the benefits of using digital productions are fully realised. Only last week there was a news story about how more than 30,000 prosecutions in England and Wales collapsed between October 2020 and September 24 because of lost, damaged or missing evidence. It is only right that in Scotland we use technology to support justice partners and being able to manage large quantities of evidence, many of which are not required to be produced for trial. I have therefore brought forward amendments that provide more certainty on the use of digital evidence. Amendment 5 provides detail on the process by which parties can apply to the court for a direction that images are not to be used in place of physical evidence. It sets out a timescale for making an application and requires the court, when considering an application, to assess whether the use of an image in place of the physical evidence would prejudice the fairness of proceedings. In summary cases, the amendments will allow parties 28 days after being given access to the images of physical productions to object and seek a direction from the court requiring the use of the physical production. In solemn cases, the same time limit applies from either service of the indictment or the defence lodging a list of productions. In addition, the amendments enable the court to consider any application to object to the use of images made after these deadlines have passed, where the party is able to demonstrate that they made the application as soon as reasonably practicable. Amendments 1, 2, 3 and 4 make consequential adjustments to the bill to allow the timescales provided by Amendment 5 to have effect and to enable an application to be dealt with at the first diet and solemn proceedings. Amendment 6 clarifies that where the bill refers to images of physical evidence, it means both moving and still images. Ultimately, our ambition for these provisions is to promote the use of modern technology using DESK, support greater efficiency across the criminal justice system and enhance the way evidence is led in order to create improvements in the court experience. Convener, during stage 1, Victim Support Scotland provided a powerful example where physical evidence being passed around in court and sexual offences cases can have a traumatising impact on victims and how this could be addressed through the use of digital productions. This represents just one of the many ways in which the use of digital productions and the digital evidence sharing capability known as DESK can be transformative for victims, witnesses and accused. I am confident that this approach balances the rights of parties and provides greater certainty about the use of production, while also supporting the desire of partners to move towards greater digitisation. And I would therefore ask that members support amendments 1 to 6 in my name. Thank you.
Thank you very much, Cabinet Secretary. So, Pauline McNeill to speak to Amendment 93 and other amendments in the group.
Thank you, Convener. Amendment 47 ensures that any change increase to the use of digital productions in court will not have an impact on the current arrangements for storage of physical evidence. Amendment 48 ensures that the physical evidence of the case cannot be destroyed while the case against the accused is ongoing, right until the appeal or review by the Scottish Criminal Cases Review Commission. And Amendment 93, and thanks to the convener for allowing that manuscript amendment. It's one of the ones that got lost in the midst of the emails. Anyway, but it does ensure that before the trial begins, either protecting or the defence can request to view the physical item, and that request can be effectively produced in court, similar to the Cabinet Secretary's and to Liam Kerr's. I want to begin by saying, well, it's really important, I think, that we establish what the principle is here of what this part of modernisation of the system does. So what I'm looking for here is where does it actually benefit the court administration and the interests of justice? So we'll start with the production of the physical evidence. Now, there's lots of cases where you think, well, it doesn't matter if it's produced digitally. But there are cases where, say it's a murder case or a weapon, I would have thought it's really important that the jury sees that. But the Cabinet Secretary's amendment, which I think is helpful, it just seems to me not to really found on the principle, which is it must be in the interest of justice for either party, whether it's the Crown or the Defence, to be able to say, even if they've missed the deadline, that they wish that to be produced in court. I'm not comfortable with there being a deadline. Oh, if you've missed the 28 days, you cannot have that produced in court. I mean, there is a best evidence rule. That's the principle of the best evidence, the best quality evidence. So I'm concerned that the bill might be throwing away important principles. Now, generally speaking, I'm interested in the status quo, and I confess I am not au fait with all of the principles of the status quo around the retention of evidence. But I do note that there will be benefits to the smooth running of the court system. It's important, I think, to separate out the issue about retention of evidence, how long that's kept for, what form it's kept in, and the question of the production of evidence. So we're dealing with two different things here. I mean, if you were confident that, say, for example, there was a digital image of a bag of heroin, if you were confident that everybody knew what that looked like, then you wouldn't worry too much, but you might not. So this is important, I think, to ensure that, that there is a full ability for that to be produced in court. Of course, yeah. Mm-hmm.
I thank the member for giving way. I suppose just referring back to some of the comments that the Cabinet Secretary made with regard to some of the circumstances that the courts can find itself in terms of the types of the huge range of types of productions that can be relevant to a case, and just to acknowledge some of them can be perishable, so it can be clothing, contaminated clothing. Marijuana, I think, was the example that the Cabinet Secretary, but also in terms of some of the trauma that can be caused where, for example, a mobile phone that has significant evidence on it is required to be retained as a production, but that in itself can be quite traumatising for a victim in particular. So just to highlight the huge and also significantly bulky items, a car, a sofa, anything like that. So just to flag that with the member.
Yeah, no, I think I agree with the convener that I think the status quo, whatever that is, I'm content with. But the bill does not. What the bill will do, though, is it say that other items that I'm talking about could be digitally produced, and if the Defence or the Crown, for whatever reason, don't apply for it to be produced in court, then it won't be. And I just think that would be contrary to the interests of justice. So I accept that there's a huge area, and I just wonder if there should be a bit more detail in the bill to prevent. Now, what my amendment does is say there should be no deadline. I just think if any case, at any point before the trial, if it's practical, and it might not be practical, why should there be a deadline to produce the weapon in court if it's in the interests of justice to do so?
I'm grateful to Ms McNeill for giving way. I think it is important to emphasise that where the physical production is critical to a case, you would of course expect the Crown to protect its position in terms of producing the physical item. Yep. And I note that Ms McNeill says that she doesn't think there should be any timeline to parties being able to object to an image being produced as opposed to a physical object. It was just to reiterate the point that I did make, that applications could be made after that if they can demonstrate that the application has been made as soon as practicable. And my final point, and I appreciate Ms McNeill's indulgence, is that my broad concern around her amendments and Mr Kerr's amendments is that they're certainly not even protecting the status quo, that they're actually moving us backwards. And I appreciate that members will have their views about how we move forward and will have their views about any proposed changes. But these amendments, don't protect the status quo and will actually make things worse for victims and justice partners.
I'm not sure I agree with their last point, because if the default is going to be digital production, then what I'm trying to get at is that it can't be done at the expense of the interests of justice. Now, I do acknowledge that the court can, but that still means the court could say, no, we're not allowing it. And I actually wonder if it's human rights proof. If the court said no, let's say it's a murder weapon, and the court said no, we're not going to allow the physical production for whatever reason, which they are entitled to do under the legislation. It just seems to me, how can that ever be fair? If either the Crown or the just think it's important for their case, and they have to answer to the court as to why they didn't, but these things, you know, these things do happen all the time. So that's why I just want to explore this, and probably think Liam Kerr's amendment is a bit more comprehensive than mine. I'll just finish with this. Paul Smith of the Edinburgh Bar Association says, at the moment, if someone is charged with the possession of a knife, that knife needs to be retained physically produced in court. Section 4.4 will allow the police to take a photograph of the knife and that photograph to become the evidence, so they will not need to produce the knife. That might lead to the original knife being lost or destroyed and not available for the defence to inspect. My concern is that if the police know that a photograph is as good as the real thing, they will take a photograph and dispose of the real thing, and thereafter it will be lost. So I think, in conclusion, I think it would just be helpful just to tidy up some of these concerns before stage 3, because whilst you can see lots of benefits that the convener outlined, I would be deeply concerned if it meant that all eyes were on the kind of efficiency of just getting everything digitalised, because that's much more efficient, and then we then lose some of the things that we already had, and it would be contrary to interests of justice if we did. Thank you very much.
Okay, thank you very much. So, Liam Kerr, to wind up and press or withdraw Amendment 44.
Thank you, Convener, and thank you, Cabinet Secretary and colleagues, for the debate. I find myself persuaded by the Cabinet Secretary's arguments for her own amendments in this section. I actually find myself persuaded by her arguments on my amendments 44 and 45, particularly regarding the courts, the burden on courts of applications and the use of desk. I think there is an interesting side question, which we'll do another time, about technology constraining legislation, but that's not for today. However, I will be pushing Amendment 46 because this amendment was in line with this committee's recommendations, and respectfully, I didn't hear strong arguments against it, but what I did hear was pretty persuasive arguments by Pauline McNeill for her amendments 47 and 93, which are largely similar to my amendment 46, but just take it further. So I will look to push amendment 46. I'm also not persuaded by the Cabinet Secretary's argument on my amendment 49, because to my mind, all that mine is saying is that evidence won't be destroyed until the appeal has been determined, not that that evidence should be kept forever. If you'll forgive me, it sounds like common sense. But of course, also, the Law Society have told us that this is necessary. The Law Society have said this is a good idea, which, again, I remind members that I am a member of the Law Society, but if they tell me something's a good idea, I will often listen to them. But finally, the Cabinet Secretary makes a reasonable and important point about that it may be financially burdensome. But it seems to me that someone's liberty might be on the line here, and that is priceless. Remember, the faculty, as I outlined in my opening comments, the faculty told us that physical items, quote, may prove decisive evidence to incriminate or exculpate the accused. And that's why I think this is so important. So, Convener, I will seek to withdraw Amendment 44, but I look forward to you asking me the questions on my other amendments.
Okay, thank you very much. So the members indicated that they wish to withdraw Amendment 44. Does the committee excuse me, have any objections? No, thank you. Excuse me. So I call Amendments 1, 2, 3 and 4, all in the name of the Cabinet Secretary, and all previously debated with Amendment 44. And I invite the Cabinet Secretary to move amendments 1 to 4 en bloc.
Moved en bloc.
Does any member object to a single question being put on amendments 1 to 4? No, thank you. So the question is that amendments 1 to 4 are agreed. Are we all agreed? Yes. Thank you. I call Amendment 45 in the name of Liam Kerr, already debated with Amendment 44. Liam Kerr to move or not move?
Not moved.
Okay. I call Amendment 5 in the name of the Cabinet Secretary, already debated with Amendment 44. Cabinet Secretary to move formally.
Moved.
Okay. The question is that Amendment 5 be agreed to. Are we all agreed?
Yes.
Thank you. I call Amendment 6 in the name of the Cabinet Secretary, already debated with Amendment 44. Cabinet Secretary to move formally.
Moved.
So the question is that Amendment 6 be agreed. Are we all agreed?
Yes.
Thank you. I call Amendment 46 in the name of Liam Kerr, already debated with Amendment 44. Liam Kerr to move or not move?
Moved.
Thank you. So the question is that Amendment 46 be agreed to. Are we all agreed? We are not agreed, so therefore we will move to a vote. So those in favour of the amendment, please raise your hands. 1, 2, 3, 4. Those opposed to the amendment, raise your hand. There are no abstentions. Thank you. So we have 4 votes for the amendment, 4 votes against. We've got no abstentions. So as there's an equality of votes as convener, I will use my casting vote and vote against the amendment. So I call Amendment 93 in the name of Pauline McNeill, already debated with Amendment 44. Pauline McNeill to move or not move?
Moved.
Thank you. The amendments, beg your pardon, the question is that Amendment 93 be agreed to. Are we all agreed? Yes. We are not agreed, therefore we will move to a vote. So those in support of the amendment, raise your hands. Those against the amendment, raise your hands. Thank you. There are no abstentions. So we have 4 votes in favour of the amendment, 4 votes against. We have no abstentions. So as there is an equality of votes, as convener, I will use my casting vote and vote against the amendment. So I beg your pardon, the amendment is therefore not agreed. So I call Amendment 47 in the name of Pauline McNeill, already debated with Amendment 44. Pauline McNeill to move or not move?
I'll come back to this at stage 3. I'll not move it.
Not move it, thank you. So I call Amendment 48 in the name of Pauline McNeill, already debated with Amendment 44. Pauline McNeill to move or not move? Not move. I call Amendment 49 in the name of Liam Kerr, already debated with Amendment 44. Liam Kerr to move or not move?
Moved.
Thank you. So the question is that Amendment 49 be agreed to. Are we all agreed? We are not agreed, so we will move to a vote. So those in favour of the amendment, please raise your hands. Those opposed to the amendment, raise your hand. Thank you. We have no abstentions. So thank you. So we have 4 votes for the amendment, 4 votes against the amendment. There are no abstentions. Therefore, as there is an equality of votes, as convener, I will use my casting vote and vote against the amendment. So the amendment is therefore not agreed. So the question is that Section 4 be agreed. Are we all agreed?
Agreed.
Thank you. And the question is that Section 5 be agreed to. Are we all agreed?
Agreed.
Thank you. Okay, so we're now going to move on to the next group, which is body-worn video, just after which we will go to a break. I'm sure members will be happy to hear. So I call Amendment 7 in the name of the Cabinet Secretary in a group on its own. Cabinet Secretary to move and speak to Amendment 7.
Convener, Amendment 7 allows the time, date and location as displayed on the footage captured by a body-worn video camera issued by Police Scotland to be treated as being sufficient evidence of those matters without police officers or staff needing to attend court to give evidence of them. There are safeguards in place for the accused who will be able to object within 7 days to the recording being treated in such a manner where they believe the footage does not, in fact, accurately display the time, date or location of the events recorded. This puts in place an evidential rule that allows for some non-controversial aspects of body-worn video evidence to be accepted by the court, reducing the need to routinely cite police officers to speak to those aspects. This will also benefit victims and witnesses by allowing cases to be brought to court sooner. This is in line with the current practice and legislation for fixed camera video footage, such as CCTV, contained within Section 283 of the Criminal Procedure Scotland Act 1995. The amendment further provides that the Scottish Ministers may by regulations enable other organisations such as the British Transport Police and the Scottish Prison Service to be added to the provision in future to allow recordings from their body-worn cameras to be covered. This ensures that primary legislation will not be necessary for other organisations to benefit from this bill, and I move Amendment 7.
Thank you very much, Cabinet Secretary. Does any other member wish to come in? If not, Cabinet Secretary, to wind up.
Wind up.
Thank you very much. So the question is that Amendment 7 be agreed to. Are we all agreed?
Agreed.
We are. We are agreed. Can I just confirm that Ms McNeill's agreed? Yes. Okay, thank you. Okay, thank you. So we will now have a short suspension for 10 minutes to allow a comfort break. Thank you. Okay, thank you very much, members. So we now move on to our next group, which is fixed penalties. And I call Amendment 50 in the name of Liam Kerr, grouped with Amendment 58. Liam Kerr to move Amendment 50 and speak to both amendments in the group.
Thank you, Convener. Amendment 50 relates to Section 6, which permanently increases the limit of the fixed penalties from £300 to £500. Section 6(1)(b) and C allows Scottish ministers to further increase that £500 by regulations, should they wish to do so. Now, my Amendment 50 simply deletes that power and thus seeks to prevent ministers from straightforwardly increasing the fixed penalty amount to a higher level. Now, my reason for that is I'm concerned that the knock-on impact of a further increase to the fiscal fine level could see far more serious crimes being dealt with by a fiscal fine. It seems to me that the £500 increase can be entirely justified on inflationary grounds, and we know that at that level it will cover offences such as shoplifting, which is, admittedly is causing huge problems to retailers, and that's another matter which we'll need to address in another forum. However, it seems to me that if the maximum fine was increased by ministers using the power as drafted to, for the sake of argument, £1,000, it seems to me not difficult to see how this would lead to more serious crimes being dealt with by means of a fiscal fine. It seems to me £500 may not be considered sufficient punishment, and so would be dealt with in another way, but £1,000 might well be seen as a sufficient punishment. And that, to me, seems to bring problems. The committee's report, again, illustrated some of these problems, where it said, one final point made about the use of fiscal fines for offences, such as shoplifting, was that the public might perceive their use as diminishing the importance with which the justice system treats such offences. And Simon Brown, of the Scottish Solicitors Bar Association, told us, at a practical level, this has been picked up in the press, we see the effective decriminalisation of shoplifting. Shoplifting becomes an offence that is viewed as a low-level crime and is dealt with by fiscal fines. And a related point is that the Scottish Conservatives obtained statistics that showed that between 2018 and 2021, more than 1 in 3 people who refused the offer of a fiscal fine had no further action taken against them. So effectively, they faced no punishment for their crime. I can supply that data to the Cabinet Secretary afterwards if she wishes, but 1 in 3 people who refused a fiscal fine had no further action taken. So the more fines issued, the higher and thus more serious the crimes, then the more serious the crimes that people are effectively getting off with. And so for that reason, I move Amendment 50 in my name.
Sharon Dowie to speak to Amendment 58 and other amendments in the group.
Thank you. My Amendment 58 requires the Scottish Ministers to publish a one-off report within 1 year of this section coming into force on the impact of the permanent increased scale of fiscal fine penalties. This report would cover an assessment of the number of fixed penalties issued, the impact of the higher permanent sum on reoffending, the impact of the permanent higher sum on victims, and whether the permanent increase in the scale of fixed penalties has a positive or negative impact on the courts. The Scottish Ministers are also able to determine other elements to include in the report. This amendment is intended to complement and tie in with Liam Kerr's Amendment 50 in this grouping, which, as we have heard, would remove the power of Scottish Ministers to increase fiscal fines beyond £500 by regulation. The committee heard some concern about the impact of permanently increasing the level of fiscal fines, such as the ability of certain individuals to pay it. It's important to monitor the impact of the increased scale of fiscal fines on reoffending rates and the impact that it has on victims. We support the permanent increase in fiscal fines in line with the general support from stakeholders and recognition of inflation. However, this should be monitored to ensure that they are being used effectively. For example, a written submission from the Scottish Women's Convention noted that it held strong reservations about how the permanent about the permanent increase. It noted the majority of those receiving fiscal fines reside in the most deprived areas in Scotland, and stated that we believe that in most cases fines worsen an individual's outcomes, placing many into further financial hardship. Adult Justice Services at the City of Edinburgh Council indicated support for the permanent increase in fiscal fine penalties, but acknowledged that there must be a realistic prospect that a fine imposed will be paid, otherwise it could increase pressure on the justice system. In recent discussions with the Law Society and Victims Support Scotland regarding this bill, both stakeholders indicated support for my amendment to monitor the use and impact of the permanent increase. Amendment 58 will improve our understanding of the use and impact of fiscal fines, address concerns raised by stakeholders, measure the impact it has on reoffending, and ensure the use of these fines gives justice to victims. Thank you.
Very much. If any other member wishes to come in, if not, Cabinet Secretary.
Convener, Amendment 50 effectively removes an existing power of the Scottish Ministers to increase the maximum level of fiscal fine by subordinate legislation. Fiscal fines are an important tool available to prosecutors to use in appropriate circumstances as a proportionate response to lower level offending. For these penalties to be effective, they need to be set at an appropriate level to address the range of circumstances for which they might be used. Modification of the maximum level is therefore required from time to time to ensure they continue to be effective and to allow court and other resources to be focused on more serious cases. The maximum level was set at £300 in 2007, where it remained until the first Emergency Coronavirus Act. As well as reducing the burden on the courts during the pandemic period, the increase also enabled inflation to be taken into account. Requiring primary legislation to change the maximum level of fiscal fine is not an efficient use of parliamentary time, would unacceptably restrict responsiveness to inflationary pressures, would lead to inefficiencies in the justice system, and would fundamentally reduce the effectiveness of fiscal fines. I would also emphasise that this is a power that has existed since 2007. All this bill is doing is updating that power to make any changes more accessible to those looking at the statute book by ensuring changes are made on the face of the Act. I therefore cannot support Amendment 50. Yes?
So, listening to that, I understand the point being made. But if that's right, why not simply make the power that the sum will be increased by the level of inflation, such that it's tied not to crime inflation, but actually to fiscal inflation? And if the Cabinet Secretary is not minded to do that, under what circumstances could she envisage increasing the level of fiscal fines?
Well, at this point in time, I have no plans, so I have no thoughts right now, and I have no plans in the short to immediate term to use the power, if indeed Scottish ministers still retain the power. It is not it's not a subordinate power that has been used often in this Parliament, bearing in mind that the upper level didn't increase from 2007 until the coronavirus pandemic hit. So, but what I put in the record, I don't have any plans post this legislation. But it is important that we future-proof.
Might come back in, but doesn't the Cabinet Secretary then concede that the level ought to increase only with inflation, such that it is tied entirely to, you've set, or the Scottish ministers have set the level at £500 and said that is the appropriate level to have it at, and so that level simply goes up with inflation, rather than being tied to any decision of the ministers to say, well, actually, let's just get more crimes encompassed within this ambit?
Well, of course, I know Mr Kerr and some of his colleagues have a very keen interest in fiscal fines, and it is a matter that has been debated every time the coronavirus legislation rules were extended on during the annual debate that we had. So let me repeat that in terms of the introduction of the higher level of fiscal fines, that increases the number of cases and doesn't increase the number of offences encompassed. And it is, in my view, appropriate that ministers have this subordinate legislation making power. It is by affirmative process, so it has to be fully, democratic and transparent. And in terms of the point that Mr Kerr makes about perhaps it being linked to inflation, that will be a point and an action for him to pursue. I have other actions that I am focused on pursuing, and right now any further changes to fiscal fines is not on the top of my list. Convener, turning to Amendment 58, in general terms, I would note that the increased level of fiscal fines have been available to prosecutors since 2020. The Parliament has had a number of opportunities to scrutinise and test the evidence available in support of their continued use. That included the passage of the Coronavirus Recovery and Reform Scotland Act 2022 and subsequent annual extensions, each requiring ministers to carry out a review and consultation before publishing a statement of reasons for extension, and I'm not persuaded that a further review of these embedded measures is needed. Turning to the specifics of the amendment, the report would have to include an assessment of the number of fiscal fines issued. This data is already published within the annual criminal proceedings data, as well as statistics published by the Crown Office. I also understand that the Lord Advocate has written regularly to the Committee on the use of higher level of fines and has offered to continue to do so. The report would also cover the impact of the higher sum on levels of reoffending and on victims involved. It would not be possible to produce anything robust on either of these aspects. There are many variables that will impact reoffending and victim experience, and it would not be possible to isolate and narrate the impact of a higher level of fiscal fine. The numbers issued are also too small to allow robust conclusions to be drawn, and whilst I agree that it's always important to consider the impact on victims, I would refer to the correspondence the committee received from Victim Support Scotland in February, in which their Chief Executive noted that victims have frequently told us that delays in the justice system can be distressing and frustrating experience. VSS is satisfied with the notion that court time will not be tied up in prosecuting crimes that can be disposed of with a fiscal fine. Furthermore, we see a benefit for witnesses who will not have to attend court to give evidence if the offer for a fine is accepted. Finally, the report would cover the impact of the new levels of fines on the courts. It's unclear how this could be assessed other than looking at the numbers issued and accepted or deemed accepted, and noting that those are all cases that did not take up court time. As I've mentioned, that information is already available, and for these reasons I cannot support Amendment 58.
Very much. So Liam Kerr to wind up and press or withdraw Amendment 50.
Thank you, Convener. Thank you to the Cabinet Secretary for the debate. I'm afraid I don't accept the argument, because if this truly was about sticking at an appropriate level and not crime inflation, if you like, then I cannot see why we wouldn't make the rise from the 500 inflationary only. We've seen, this committee has seen the consequences of fiscal fines already, with the Scottish Solicitors Bar Association, as I mentioned in my opening remarks, telling us that their view was shoplifting was effectively decriminalised. Of course I will. Of course I will.
Let me put in the record and assure him, in terms of the information that comes over my desk, I can assure you, and people will have their views on this, whether this is a positive or negative thing, but I can assure you that we're still incarcerating people on shoplifting offences.
Yes, I understand the point being made. However, we cannot get over that, as I said in my opening remarks, Simon Brown of the Scottish Solicitors Bar Association told this committee, at a practical level, we see the effective decriminalisation of shoplifting. Shoplifting becomes an offence that is viewed as a low-level crime. So whilst I understand the point the Cabinet Secretary is making, we have to think how this is viewed, and that was the point being made by the witnesses to this committee. And finally, one of the reasons why I'm not persuaded by the Cabinet Secretary's arguments was because she said very clearly, look, you know, this Cabinet Secretary has no plans to increase the level of fiscal fines. She's got other things to be dealing with. And of course, I completely understand that. But there is a reshuffle going on right at this moment, as I understand it, and indeed an election pending in less than 12 months. So when the Cabinet Secretary said in her remarks that we need to future-proof this legislation, I would argue she makes my point for me. And for that reason, I press Amendment 50.
Okay, thank you very much indeed. So the question is that Amendment 50 be agreed to. Are we all agreed?
Yes.
Are we all agreed?
Yes. No.
Thank you. We are not agreed. Therefore, we will go to a vote. So those in favour of the amendment, raise your hand. Thank you. Those opposed to the amendment, raise your hand. There are no abstentions. Thank you. So we have 4 votes for the amendment, 4 votes against the amendment and no abstentions. So as there is an equality of votes as convener, I will use my casting vote and vote against the amendment. So the amendment is therefore not agreed. So the question is that Section 6 be agreed to. Are we all agreed? Thank you. So I call Amendment 58 in the name of Sharon Dowie, already debated with Amendment 50. Sharon Dowie, to move or not move?
Thank you. I take on board the Cabinet Secretary's comments. I'm still not convinced that there's enough been done to see that the penalties are effective. So I'm going to look at the comments after committee, and I think I want to bring it back at stage 3, I think, so I won't push at the moment.
So you're not moving the amendment? Okay, thank you very much. Okay, so we now move to the next section, which is the next group, which is national jurisdiction. And I call Amendment 59 in the name of Sharon Dowie, grouped with amendments as shown in the groupings. And I point out that if Amendment 8 is agreed to, I cannot call Amendment 52. So, Sharon Dowie to move Amendment 59 and speak to all the amendments in the group.
Thank you. Amendment 59 ensures that when deciding whether there should be a national jurisdiction calling from custody, there must be consideration of the individual circumstances of the case by the Lord Advocate or Procurator Fiscal. This could include circumstances such as travel and time expenses for victims, witnesses, the defence and prosecution. Amendment 59 addresses the various practical issues related to the travel and cost implications of national jurisdiction, which were raised by stakeholders such as Victim Support Scotland, the Law Society of Scotland, the Scottish Solicitors Bar Association, the Edinburgh Bar Association and Police Scotland. In recent discussions on this bill with Victim Support Scotland, they are keen to ensure that there would be no undue burdens on the ability of victims and witnesses to travel. Victim Support Scotland emphasised that victims cannot be expected to travel long distances and take additional time out of their day to attend court. There needs to be a strong consideration of expanding the options for remote evidence, including the acceptable locations from where witnesses can give evidence, as my colleague Liam Kerr's amendment tried to deal with. Amendment 59 would simply require that all circumstances in an individual case must be considered before making a national jurisdiction calling from custody. This aims to ensure there is no unfair burden on any one of the parties involved.
Much. So, Pauline McNeill to speak to Amendment 51 and other amendments in the group.
Thank you. Convener, Amendment 51 ensures that national jurisdiction can only be for the initial custody hearing, and beyond that only with agreement of the defence. Following that, jurisdiction should remain linked to the locus of the offence. Simon Brown from Scottish Criminal Bar Association said the issue is the plummeting number of defence solicitors available to deal with this work. and the concomitant difficulties that places on being able to deal with cases out with ones in normal practice areas. If we were in a situation where I had a sheriff and jury accused out on a bail for a case I assumed I'd be prosecuting Kilmarnock, I'd be faced with considerable logistical difficulties were that matter to be indicted, say, for example, in Greenock. Amendment 52 ensures that national jurisdiction remains at the point of liberation on bail. Further to that, Simon Brown also said, when I asked him, the issue, though, is that those fully committed for trial and therefore remanded in custody are only a relatively minor percentage of solemn cases. The vast majority of solemn proceedings commence with the case against the accused being continued for further examination and the accused liberated on bail. We would require a similar undertaking at national jurisdiction which end at the point of elimination on bail to make the system workable. Can I welcome the amendment in the Cabinet Secretary's name, which is clarity which I had been trying to seek at stage one about how far the national jurisdiction would be allowable in relation to various proceedings. So I think that is, in simple terms, it's not the trial, but it can be proceedings before that. But I think what you're hearing from Sharon Dowie and myself, I'm sure I don't need to mention the crisis again has appeared this week in the press about losing criminal defence lawyers. I don't think the government seemed to have taken this into account when the legislatures for national jurisdiction, because you've got to hope that everyone will be sensible about it and not have lawyers or victims going up and down. I suppose it's less about victims because it will be procedural hearings, but defence lawyers and accused persons, particularly when we have people leaving the criminal bar, it is going to cause practical difficulties. So, I mean, I think it's sensible to have national jurisdiction for custody hearings, especially, to me, the way I read the bill was that we're trying to introduce a default for virtual appearance for custodies, which does make sense. You can see the efficiency in that. But you've got to remember the national jurisdiction isn't just about virtual appearance, it's for physical appearances. And I'm just a bit concerned that what the practical impact might have in actually solicitors being able to actually conduct their business if they are in different sheriff courts for different things on that.
Very much. Okay, so Cabinet Secretary to speak to Amendment 8 and other amendments in the group.
Convener, we are in the unusual yet fortunate position that many of the provisions in this bill mirror those that have been in force for over 5 years since the emergency legislation passed in the early weeks of the pandemic. Throughout this time, we have engaged with Justice Partners to identify how the provisions have been working in practice, and committee has heard evidence on that, both through the Stage 1 process and in previous years when considering an extension of temporary frameworks. Stakeholders and Justice Partners have consistently told us that national jurisdiction provides flexibility to allow custody hearings to be managed quickly and efficiently, ensuring that the accused does not have to be transferred from one court to another for what are often short hearings. Where the accused is subject to a number of outstanding warrants, national jurisdiction hearings can also facilitate bringing these together for pleas and sentencing, minimising churn in the court business. Turning to Amendment 59 by Sharon Dowie, prosecutors take decisions based on the public interest. They are bound by the prosecution code and guidance issued by the Lord Advocate. It is not necessary to require them to consider the facts and circumstances of the case, as that is a fundamental part of their approach. It would not be appropriate for them to make decisions based on cost and expense incurred by others. National custody jurisdiction does not include trials, so the requirement to consider travelling time and expenses of witnesses is not relevant. In any event, it is unclear how prosecutors would know that type of information at the stage of marking a custody. They may not even know the identity of the accused's lawyer at that point. This amendment would introduce unnecessary and onerous obligations on prosecutors, and therefore I cannot support it. The other amendments in this group seek to adjust the end point of national jurisdiction. Amendments 51 and 53 from Ms McNeill provide that the continuation of national jurisdiction beyond the initial custody appearance is subject to the accused's agreement, and I'm not persuaded of the merits of an approach which matters of the court's jurisdiction are subject to a veto by the accused. Amendment 52 places the provision in the bill that ends national jurisdiction in solemn proceedings upon full committal, with provisions that ends it after bail has been granted. While this may be intended to provide a clear endpoint before a trial, the effect would actually be to extend the court's national jurisdiction in solemn custody cases where the accused has been formally committed and not released in bail. And this is contrary to the approach of the last 5 years and committee's Stage 1 recommendations, and therefore I cannot support any of Ms McNeill's amendments. I have lodged my own amendments and I would urge committee to support them, and which I believe these amendments would also address what I see as the intention behind Ms McNeill's Amendment 52. My amendments 8 and 10 make it clear that the default will be for national jurisdiction to end following initial custody hearings, and it will only be in specific circumstances that national jurisdiction will continue until the conclusion of a case. These provide that national jurisdiction in solemn proceedings will come to an end at the point where the accused is fully committed. They also recognise that not all accused will be fully committed, as this is not a compulsory step where the accused has been bailed. As such, my amendments further provide that where there is no full committal, national jurisdiction can only continue where an accused pleads guilty before the first diet. This also makes it clear that first diets and any subsequent solemn proceedings cannot be heard under national jurisdiction. Yes.
Check that I'm understanding what you've said. So essentially, national jurisdiction could apply up to full committal, and so that means that some hearings, like procedural hearings, preliminary hearings, could be done under national jurisdiction. But did you say that your expectation was it would be mainly used for custody appearances? Or are you expecting that it might be used? Because that is essentially the big problem, I think, which is if the hearings can be heard anywhere in Scotland prior to full committal, then you might have lawyers running up and down. Yeah. But did you say that you would expect the custody hearing, the first appearance, to be national jurisdiction?
So what I said is that Amendments 8 and 10 make it clear that the default will be for national jurisdiction to end following initial custody hearings. And it would only be in very specific circumstances that national jurisdiction will continue until the conclusion of a case. And I think the example I gave was recognising that in terms of solemn proceedings, that recognising that not all accused will be fully committed. So that's not a compulsory step, for example, if the accused has been bailed.
Thank you.
Amendment 8, convener, sets out these changes for sheriff court proceedings, both summary and solemn, and Amendment 10 replicates this for proceedings in the Justice of the Peace Court. Amendments 9 and 11 respond to concerns Katie Clark raised with me about how national jurisdiction applies to an accused who is appearing following an earlier failure to appear in principal proceedings and is due to be sentenced in respect of those principal proceedings. And my amendments provide that in these circumstances, the National Jurisdiction Court can only pass a sentence or otherwise dispose of the principal proceedings where there has not been an evidence-led trial, or where there has been an evidence-led trial only in circumstances where it is considered in the interests of justice to do so. An example of that might include where the accused changed their plea to guilty early on in the trial, and so very limited evidence was heard. Amendment 9 covers proceedings in the Sheriff Courts, and Amendment 11 covers those in the Justice of Peace Courts. Convener, while I have introduced amendments that clarify the end point for national jurisdiction, as well as adding some limitations to sentencing under national jurisdiction, Justice partners have warned of the risks of introducing additional complexity by making disproportionate changes to a system that is well understood by justice partners and practitioners. I would therefore ask members to support my amendments which respond to the committee's recommendation at stage 1 and provide clarity over the endpoint of national jurisdiction while preserving the progress made to make better use of resources as well as protecting the rights of the accused.
Thank you very much, Cabinet Secretary. So, Sharon Dowie to wind up and press or withdraw Amendment 59.
I will withdraw Amendment 59.
Okay, thank you very much. So, the members indicated that they wish to withdraw Amendment 59. Does the committee have any objections? Okay, thank you very much. So I call Amendment 51 in the name of Pauline McNeill, already debated with Amendment 59. Pauline McNeill, to move or not move?
Not moved.
So I call Amendment 8 in the name of the Cabinet Secretary, already debated with Amendment 59. And I remind members that if Amendment 8 is agreed to, I cannot call Amendment 52 due to preemption. So, Cabinet Secretary, to move formally.
Moved.
So the question is that Amendment 8 be agreed to. Are we all agreed?
Yes.
We are agreed. Thank you. So I call Amendment 9 in the name of the Cabinet Secretary, already debated with Amendment 59. Cabinet Secretary, to move formally.
Moved.
Thank you. So the question is that Amendment 9 be agreed to. Are we all agreed?
Yes.
Thank you. I call Amendment 53 in the name of Pauline McNeill, already debated with Amendment 59. Pauline McNeill, to move or not move?
Not moved.
I call Amendment 10 in the name of the Cabinet Secretary, already debated with Amendment 59. Cabinet Secretary, to move formally.
Moved.
Okay. So the question is that Amendment 10 be agreed to. Are we all agreed?
Yes.
Thank you. I call Amendment 11 in the name of the Cabinet Secretary, already debated with Amendment 59. Cabinet Secretary, to move formally.
Moved.
So the question is that Amendment 11 be agreed to. Are we all agreed?
Yes.
Yes. So the question is that Section 7 be agreed to. Are we all agreed? Thank you. The question is that Section 8 be agreed to. Are we all agreed?
Agreed.
Thank you. Okay, so we now move on to our next group, which is review of jurisdiction for connected proceedings. And I call Amendment 54 in the name of Maggie Chapman in a group on its own. Maggie Chapman, to move and speak to Amendment 54.
Thank you very much, Convener, and good morning, Committee. Good morning, Cabinet Secretary. Before I begin, can I just refer colleagues to my register of interests? I worked for a rape crisis centre before I was elected. I move the amendment in my name. This amendment seeks to address the widely acknowledged and long-standing problem of how domestic abuse is treated within child contact proceedings. And this comes out of conversations with Scottish Women's Aid and others, as it's become clear that we need to tackle this issue. Professor Marianne Hester of the University of Bristol has written about the three-planet model. She describes the domestic violence planet, where domestic violence is the crime at question. The usually father's behaviour is recognised by the police and other agencies as being abusive to the mother. So the father could be prosecuted or have orders taken out against him, that kind of thing. At the same time, support agencies provide protection and refuge for the mother. The civil and criminal laws provide intervention and support mechanisms, and on this planet, the focus is on violent male partners who need to be contained and controlled in some way to ensure that women and children are kept safe. Then we have the child protection planet. When children are living with a mother who is experiencing domestic violence, this other planet becomes involved where a different set of professionals occupy. Here, public law deals with child protection, and the emphasis is on the welfare of the child and that child's carer. In order to protect the children, social workers are likely to insist that the mother removes herself and her children, despite professionals identifying that the threat or violence comes from the man. It's the mother who's seen as responsible for dealing with the consequences, and the violent man effectively disappears from the picture. On the third planet, the child contact planet, there's yet another population because a different set of professionals reside here, governed by private, not public law. And this has tended to place less emphasis on child protection and more on the idea that children should have two parents. In this context, an abusive father may still be deemed a good enough father who should at least have contact with, if not custody or residence of, his child post-separation. So the mother who has tried to protect the child from his violent behaviour by calling the police and supporting his prosecution on the domestic violence planet, and by leaving him as instructed on the child protection planet, is now ordered to allow contact between her violent partner and children, leaving her confused and potentially fearful yet again for the safety of her children. Clearly, the challenge is how we bring these three planets into alignment so that the safety of women and children becomes paramount. And this requires a better understanding of the dynamics of domestic violence and a coordinated approach by all the agencies and services involved. It is also vital, I believe, that a gap is closed, the gap between violent men on one hand and fathers on the other, so men can be dealt with as both at the same time. So it is a cross-jurisdictional problem. In the Scottish context, this issue has been discussed by the Law Society, the Commissioner for Children and Young People, and others. And a recent report by the Scottish Centre for Crime and Justice Research identified key problems, including a lack of mechanisms to communicate information between different court proceedings, and a limited and siloed understanding and consideration of domestic abuse by the judiciary. There have been various recommendations made, some of which have been implemented, but we know that the problems persist, often at huge cost to the well-being of women and children. Scottish Women's Aid have suggested that a further significant and potentially highly effective reform would be to ensure that, where possible, the same sheriff would hear both the domestic abuse and the child contact cases. This would make it much more likely that the evidence of abuse and its effects would be properly considered in all their depth and breadth, and the gulf between those planets that Marion Hester described could be bridged. Yes.
Thank Maggie Chapman for giving way, and you may have covered it already in your opening remarks, and I maybe just missed it, but are you aware of any evidence or feedback that would suggest that, to a certain extent, courts are already attempting to make this arrangement that you're proposing work, without there being a requirement for a legislative provision for it?
Yes, so there are mechanisms in place, non-legislative mechanisms in place, but there are still questions and concerns around the sharing of information, the sharing of data, and actually, importantly, an understanding of the consequences of women and their children having to appear in these different settings with different professionals, being re-traumatised, having to tell stories again, having to justify why they are afraid of being in the same, of allowing child contact, having to justify to a different set of professionals. That's still happening. And I believe if we are serious about undertaking a genuinely trauma-informed approach to our justice system as a whole, there is more that we can do. So I did originally want to bring an amendment to this that would, where possible, allow for the same sheriff to cover both domestic abuse and child contact cases, but I appreciate this is outside the scope of this bill. So what my amendment before us today does is not require that reform, but a review to be carried out with the benefit of expert input from the Lord Advocate and other specialist organisations, those with deep experience and expertise in these issues. It shouldn't be beyond the wit of both our legal systems and our politicians to work out a way to better support and protect, particularly women and children in domestic abuse and any related or connected child contact situations. Thank you.
Thank you very much. So I bring in Rona Mackay.
Thank you. I want to thank Maggie for bringing this to the committee, and I completely agree with what she's saying. Everything is what she's saying. I think it's really good to raise it. My only concern is that maybe this isn't the correct bill for it. I think it maybe should be in the Victims and Witnesses Bill, and maybe that's something that the Cabinet Secretary will address. But I completely understand your argument and actually do agree with it. Thank you.
Thank you very much. If no other member wishes to come in, Cabinet Secretary.
Convener, the Scottish Government recognises the issues which Ms Chapman is seeking to address in her amendment. There is entirely understandably a growing focus on domestic abuse in civil cases, and as Ms Chapman mentions in her amendment, particularly in family cases relating to matters such as child contact and residence. The civil criminal interface on domestic abuse is of specific concern, given that there could be a criminal case on domestic abuse and a parallel civil proceedings on child contact where the domestic abuse is raised. And the Scottish Government has a programme of work to consider and tackle the problems in this area. I outlined work we are doing or plan to do when responding on the 12th of March this year at stage 2 of the Victims, Witness and Justice Reform Scotland Bill to an amendment that was lodged by Russell Finlay MSP, and I'll briefly run through again what we are doing. First of all, we have an ongoing work using improvement methodology to consider the criminal-civil interface in relation to domestic abuse. And this included 2 workshops last year with justice agencies and with the voluntary sector. And we are considering possible changes to take forward. Secondly, as I said on the 12th of March this year, that the Scottish Government would carry out further research on integrated domestic abuse courts, and these courts can look at both civil and criminal aspects of domestic abuse, and they operate in some other jurisdictions. And our work on this research has started, and we will publish our findings. Thirdly, I also said on the 12th of March that the Scottish Government would prepare a policy paper on proposed civil court rules to go to the Scottish Civil Justice Council. Rules are made by the courts rather than by government, but we can and do put forward proposals. And this paper will propose changes to court rules about the information regarding domestic abuse and sexual assault that is provided to civil courts. A draft of that policy paper will be ready by the start of stage 3 of the Victims, Witness and Justice Reform Bill. And finally, we intend to consider if the Scottish Ministers should make regulations to confer on the courts a power to make an order in relation to a person who has behaved in a vexatious manner in civil proceedings. This reflects that it has been suggested to us that some people may raise repeated court cases to continue their domestic abuse. Before making any such regulations, the Scottish Ministers must consult the Lord President, which I intend to do. As I say, I very much recognise the concerns raised by Ms Chapman. I'm not entirely certain that they are for this bill, but I do nonetheless recognise the issues she raises. However, given that the Scottish Government has a number of pieces of work already underway in this area, I would ask Ms Chapman not to press her amendment.
And Liam Kerr first.
Well, just on that point, because I listened to Rona Mackay's comment earlier. So if the Cabinet Secretary is not persuaded that this is an amendment for this bill, does that mean the Cabinet Secretary is receptive, were Maggie Chapman to bring it forward in the Victims Bill at stage 3?
So, bearing in mind the scope of work, I think that is a possibility, but I do want to see some of that work come to fruition before I sit here in June and make a commitment for proceedings that are still a few months away. I suppose what I'm trying to demonstrate to both Ms Chapman and to other members is that there is extensive work ongoing in this area, and perhaps if I just say a wee bit more about it in terms of timelines, in terms of the research on integrated domestic abuse courts that is being undertaken now. The project initiation document has been finalised now, and our intention is to complete and publish the research early in 2026. The policy paper for the Scottish Civil Justice Council on court rules will be ready, as I said in my remarks, by the beginning of September, prior to or as we embark upon stage 3 on that bill. I can't obviously give timescales. I can't. It's not for me to place timescales on the Scottish Civil Justice Council. And as I've said, I'm seeking advice on regulations under Section 102 of the Courts Reform Scotland Act 2014, with a view to giving powers to the civil courts to make orders in relation to a person who's behaved in a vexatious manner. And I will be writing to the Lord President. As I said, I have to consult him later on in this month. It is, yeah, of course, Maggie, of course, Mr. Chairman, of course.
Thank you, and I appreciate those comments. When you were going through and thank you for the timelines, that's helpful to know too. When you were going through the list of work underway, you talked about work to improve the civil criminal interface. And I just wondered, because in conversations in the last few weeks with Scottish Women's Aid, there's been a sense that some of that work has shifted in focus, and actually we've lost the focus of supporting and protecting the victim survivor and any children in those cases, and it's sort of shifted back to maybe a non-trauma informed approach. And I just wondered if she could say a little bit more about that.
Well, I would be happy to engage directly with Scottish Women's Aid on that, because I do not want that to be either the perception or the reality. And as Ms Chapman mentioned, the ongoing improvement work following the workshops that we have undertaken with partners. I mean, there are 10 areas identified that need work in more detail, and that's around training, data sharing, court processes and structured case management, and some of which Ms Chapman also developed. But as opposed to me making promises here now that I can't keep, but other than to say that, you know, I will want to give a fair hearing to all of this, and we'll be considering matters further over the summer. I've also got a meeting with Mr Finlay, but I would also be happy to meet with Ms Chapman and separately, or indeed together with Scottish Women's Aid over the summer, so that we can at least ensure there's a fresh pair of eyes over where we're at and what the timescales are and what the journey ahead is.
Okay. Thank you.
Okay. Thank you very much. I take it that's the Cabinet Secretary concluded?
Yes.
Thank you. Okay, thank you. So Maggie Chapman to wind up and Presser withdraw Amendment 54.
Thank you very much, Convener. I'm grateful to the Cabinet Secretary for her comments this morning, and I will take her up on that opportunity to have further discussions, and on that basis I will withdraw this amendment. Thank you.
Okay, thank you very much. So the members indicated that they wish to withdraw Amendment 54. Does the committee have any objection? No. Okay, thank you very much. So we now move on to our next grouping, which is Report on Time Limits for Solemn Proceedings. And I call Amendment 55 in the name of Liam Kerr in a group on its own. Liam Kerr to move and speak to Amendment 55.
Thank you, Convener. Amendment 55 comes right at the end of Part 1 and the modernisation of the court provisions. Now, as we know, the current temporary provisions extending certain time limits in solemn cases will revert on the 30th of November 2025 to the previous pre-pandemic time limits for new cases entering the system. Now, this is something this committee interrogated quite a lot during this process, and the Cabinet Secretary moved on this recently, which I believe is commendable and welcome. However, there were significant concerns raised during this process that the reversion was not without risk, including the Law Society in our committee's report, who said it is very difficult to see the courts getting back on track to the point where we will have trials within, for example, the 12-month time limit that applies in a bail case, due, end quote, due to the capacity of courts to accommodate trials. In the committee's report, we also quote the Scottish Solicitors Bar Association, who said the time limits are being extended on a daily basis. They are nowhere near pre-pandemic time limits. Time bars have been extended in just about every solemn case that I deal with. And finally, our report quotes the SCTS, who, when asked if the system was on track for a return to pre-pandemic time limits, said the short answer is no. So my Amendment 55 simply looks to address these concerns and simply provides that ministers must prepare and publish a report within 1 year of the solemn courts reverting to pre-pandemic time limits in order to determine whether courts have been able to meet the time limits and what further measures might be needed if they are not being met. So I move Amendment 55 in my name.
Okay, thank you very much. Okay, so Cabinet Secretary.
Thank you, Convener. I've listened very carefully to Mr Kerr and the position he has put forward for his amendment. I am, of course, aware that there has been a great deal of debate on the subject of the extended time limits put in place to assist the criminal justice system in managing the backlog of cases that has built up as a result of the pandemic. There has been significant progress in addressing those backlogs, and it is for this reason that the only time limit extension provisions that remain in effect as of today are those related to solemn cases, and these will expire later this year on the 30th of November. As I set out to members when the Coronavirus Recovery and Reform Scotland Act 2022 Savings Provision Regulations 25 were considered by this committee in April this year, justice agencies have not raised concerns with me about the transition back to pre-pandemic time limits, provided appropriate saving provisions is put in place. I understand that this amendment is focused on how prosecutors and courts manage the transition. However, I have concerns about how this amendment is framed. Convener, I do not think it would be appropriate for the Scottish Ministers to report on the court's ability to comply with criminal procedure time limits. This is because under the Judiciary and Court Scotland Act 2008, which was supported by all parties in this Parliament, the Lord President is, as head of the Judiciary, responsible for the management of court business. The role of prosecutors is relevant too, and they, of course, are also operationally independent of the Scottish Ministers. The reporting requirement would, in effect, be asking the Scottish Ministers to offer an opinion on how court business is being managed by the Crown Office and Judiciary, and I don't think that that would be appropriate. I also think it's important to highlight a number of other issues with Amendment 55. The amendment requires information to be broken down by reference to the position before and after the changes made by the Coronavirus Recovery and Reform Scotland Act 2022 came into effect. However, that Act simply reenacted changes to time limits that were first made in the Coronavirus Scotland Act 2020, passed in the early weeks of the pandemic. As such, this reference point would effectively provide information about the extended time limits, but not information on the pre-pandemic time limits. Also, there is an issue in the concept of a time limit being met. Both time limits can be extended on application to the court on a case-by-case basis. It's not clear whether it is intended whether these would be considered as met, as a new time limit would be as extended, or not met because the extension had to be applied. The proposed reporting period of 1 year from the date on which provisions in the 2022 Act cease to have effect is also too short. This is because, in light of the Coronavirus Recovery Reform Scotland Act 2022 Savings Provision Regulations 25, cases which are subject to the time limits set by the coronavirus legislation will continue to be in the system for a considerable time after the provisions themselves have expired. Indeed, there will still be cases subject to the pandemic-era time limits in the system for 6 months beyond the point at which the amendment requires the report to be published. Furthermore, as the pre-pandemic time limit for commencement of a trial where an accused is granted bail is 12 months, no cases will have breached this time limit at the point where the report has to be published. More generally, I am not persuaded that a reporting requirement of this kind is the best way to monitor the transition back to pre-pandemic time limits. Scottish Courts and Tribunal Service already publishes extensive information about court business on its website on a monthly basis, including the average time between pleading diets and evidence-led trial in Sheriff, Solemn and High Court cases. And this has informed the Scottish Government's understanding of how the courts have been managing the backlog of cases that built up during the pandemic. And of course, if for any reason committee or any MSP want to garner more specific information, it's of course open to them to request additional information from any justice agency. And for the reasons offered, I would therefore ask Mr Kerr not to press Amendment 55, and if he does, I would ask committee to vote against it.
Very much, Cabinet Secretary. So Liam Kerr to wind up and press or withdraw Amendment 55.
Thank you, and thank you to the Cabinet Secretary. I listened with great interest to that, and I am sympathetic to an awful lot of what the Cabinet Secretary is putting before us there. I might counter, yes, of course the Lord President is the head of the service and independent, but surely in the system that we've got, ministers must have some oversight of what is going on. And bear in mind, I'm not in my amendment asking for any opinion. What I'm asking for is that we have some way of scrutinising compliance with the timescales and the ability of the service to meet the timescales, and what this Parliament and what this government can do to help and to properly resource the system to make sure it works as best possible. And I go back to, look, we heard very powerful testimony, which I referred to earlier on, about what's happening in the courts and what might happen once the timescales revert. Which does cause me great concern. I'm sure it causes fellow committee members great concern. That having been said, as I say, I think the Cabinet Secretary spoke persuasively, and perhaps this is not the right route to do this. What I would like to do, and I know the Cabinet Secretary is receptive to this sort of thing, that I will be withdrawing. I won't push this amendment today. I would like to work with the Cabinet Secretary offline to work out what the best way to achieve the end game, because I suspect that we share the drive to do things as efficiently and the best way possible. But perhaps there's a better way to do that than Amendment 55. And so for that reason, Convener, I withdraw Amendment 55.
Thank you very much. So the members indicated that they wish to withdraw Amendment 55. Does the committee have any objections? No? Okay, thank you very much. So we now move on to our next grouping, which is Part 2 reviews, expansion to include events after death. And I call Amendment 12 in the name of the Cabinet Secretary, grouped with Amendments 13, 19 and 21. Cabinet Secretary to move Amendment 12 and speak to all the amendments in the group.
Convener, my amendments in this group would provide for the expansion of domestic homicide and suicide reviews in certain defined circumstances. At present, the bill enables reviews which can learn lessons from the death and the circumstances leading up to it, but not beyond. These amendments allow a review to consider the aftermath of a death in circumstances where the victim and perpetrator were partners or ex-partners, and where at the time of the death either of them had a child who was a young person or an adult at risk. It also applies if there was a young person who was not their child living in their household at the time of the death. The amendments will enable greater understanding of what happens to these bereaved persons following a death, whether their views are sought on decisions that impact them, and whether these views are considered by professionals in making their decisions. Amendment 19 makes provision allowing the remit to be expanded beyond the point of death, sets out the persons to whom the expansion applies, and sets the parameters of what can be examined within an expanded review. The amendments also set out that the consent of the Lord Advocate is required before the remit of the review can be expanded, and this is to ensure that any live criminal investigation or proceedings are not jeopardised. Amendments 12 and 13 make consequential changes to Section 9, which describes what a domestic homicide and suicide review is. This simply reflects the fact that in some cases a review may now be expanded beyond the point of death under Amendment 19. Amendment 21 makes consequential changes to Section 17 of the Bill. This requires the terms of reference of a review to reflect any expansion of the remit, It also allows the review remit to be adjusted later on to cover any cases where it is appropriate to revisit the initial decision about whether or not to expand the review remit. This allows for flexibility. However, it continues to be the case that the Lord Advocate's consent is required for any extension, so the same safeguards apply to any initial decision on whether to expand the remit of a review. The expansion of the review to consider relevant bereaved persons following a domestic homicide or suicide is in line with the UNCRC and specifically Article 12, which states that children and young people have the human right to have opinions and these opinions to be heard and taken seriously. By expanding the review model in such circumstances, domestic homicide and suicide reviews will help to learn from the aftermaths of such deaths to improve practice, implement change and better safeguard children, young people and supported adults. And I move Amendment 12.
Thank you very much, Cabinet Secretary. So if no other member wants to come in, Cabinet Secretary to wind up with any further remarks?
No further remarks.
Thank you very much. So the question is that Amendment 12 be agreed. Are we all agreed?
Yes.
Thank you. I call Amendment 13 in the name of the Cabinet Secretary, already debated with Amendment 12. Cabinet Secretary to move formally.
Moved.
Thank you. The question is that Amendment 13 be agreed to. Are we all agreed?
Yes.
Thank you. Okay, so we now move on to our next grouping, which is Part 2 reviews, familial homicide and honour killing. And I call Amendment 60 in the name of Sharon Dowie, grouped with amendments as shown in the groupings. And I point out that if Amendment 31, that's in the group Part 2 reviews case reports, is agreed to, I cannot call Amendment 91 in this group due to preemption. So Sharon Dowie to move Amendment 60 and speak to all amendments in the group.
Thank you. The Cabinet Secretary's amendments restrict the definition of domestic abuse in this bill to the definition in the 2018 Domestic Abuse Act, namely to abusive behaviour between partners and ex-partners. This reflects the concerns this committee heard from experts during its evidence gathering around the potential to undermine the definition of domestic abuse in this bill, as was acknowledged in the committee's Stage 1 report. We support these amendments, but as a result, my amendments to introduce familial homicide and honour killings as part of a domestic homicide or suicide review conflict with this. My intention was to reflect the support for the inclusion of honour killings, in particular within the scope of this bill, as in the committee's Stage 1 report. For example, Emily Test, Victim Support Scotland and the Equality and Human Rights Commission all indicated support for a wider definition here. My amendments would have extended the scope of reviews to cover familial homicide and honour killings. They provide two options: to include it in the bill immediately or to require ministers to create regulations allowing for this within 2 years of the bill coming into force. They also provide a definition of family for this purpose. As a result of the Cabinet Secretary's amendments, I will not be pushing these amendments today, but will look at how best to bring these forward at Stage 3. However, given that the bill retains the ability of ministers to expand the scope of reviews in future, and the Cabinet Secretary references honour killings specifically in her letter to the committee as one of the reasons for this, can I ask her under what circumstances she would use these powers to include honour killings in the scope of reviews, and if she has a timeline for doing so? Thank you.
Okay, thank you very much. So Cabinet Secretary to speak to Amendment 16 and other amendments in the group.
Convener, I would like to take the opportunity to make it clear to the committee that I fully intend to include so-called honour killings within the review model. However, there is ongoing work which needs to be concluded before that can be achieved. I am referring to work currently being undertaken by the Scottish Government and stakeholders to develop a policy definition of what so-called honour abuse means in a Scottish context, and this will lay the foundation for how we then look to define these types of deaths for review purposes. Whilst I share Ms Dowie's ambition to bring so-called honour killings into scope of the review model, I cannot support Amendments 60 to 76 or Amendments 78 to 91 for a number of reasons, and obviously I acknowledge Ms Dowie's remarks that she made with her intentions, but I'll go through the reasons anyway, because I think it's I think it's helpful that they're on the record and will hopefully help us as we work together. The first reason is that at present neither familiar homicide nor honour killings are defined in a Scottish context. And while I recognise that Amendment 67 includes time for a definition of familial homicide to be developed, there is no such work underway, and my understanding is that there is not sufficient appetite to include familial homicide without an honour context in the model, although there is a strong desire to see so-called honour killings included. Turning from the regulation-making power to the amendments which include this extra category of death in the model with immediate effect, these amendments look to define so-called honour killings in fairly broad terms in order to capture the wider set of relationships that such abuse and deaths include. However, the consequences of broadening it in this way is that it would significantly expand the model and create delivery risks. The broadening of the scope to familial homicide also would include circumstances where there is no domestic abuse link or so-called honour killing link. Such deaths go out with the focus of the proposed review model and would risk overwhelming it if they were to be included from the outset. The amendments make no reference to the important context of perceived, and I emphasise perceived, dishonour and shame of a victim is said to have brought upon their family, extended family and community. At the same time, I am concerned the definition is too narrow in the context of so-called honour killings, as it only captures close family members and does not cover the full range of possible perpetrators. Therefore, while the definition is on one hand too broad and would bring a wider range of deaths into the model scope, it is at the same time likely to narrow and cuts across the work currently being undertaken by stakeholders to define what so-called honour abuse means in a Scottish context. For similar reasons, I cannot support Amendment 67, which requires the Scottish Ministers make regulations in relation to both familial homicide and honour killings. The coverage, which includes familial homicide and not just honour killings, is too broad. However, you do have my commitment that reviews will be extended to include so-called honour killings, and in the event that there is a desire in future to include broader familial homicide, then the bill already contains powers to extend the scope of the model with the necessary flexibility. I therefore cannot support these amendments, but I reiterate my absolute commitment to ensure that the review model does extend to so-called honour killings at the appropriate time and when the crucial preparatory work to which I have referred to has been undertaken. And I would be very happy to discuss this further with Ms Dowie ahead of stage 3 to set out the detail of the work that is already happening in this regard. And I would therefore ask that Ms Dowie does not press these amendments. And of course she's intimated that. Turning to Amendment 16, this amends the regulation-making power under Section 10 of the Bill. This power enables the Scottish Ministers to expand the review model to include further types of death arising from abusive behaviour, and it is this power which will be used to add so-called honour killings to the review model. Amendment 16 allows adjustments to be made to the considerations to be weighed by the Review Oversight Committee at SIFT stage, so that the SIFT can be altered when the scope of the review model is being adjusted. This amendment has been prompted by the need we identified to adjust the SIFT criteria at stage 2 in light of my Amendment 14 in the next group, which relates to anchoring reviewable deaths in a domestic abuse context. This has shown that it will not always necessarily be possible to alter the scope of the review sufficiently through a change to the definition alone, and it may be necessary to combine this with changes to the SIFT mechanism to get the correct result. The same may well apply when the scope of reviews is widened under Section 10 in future, and so-called honour killings is a salient example where there will be a need to adjust the SIFT criteria. Amendment 16 is therefore an important amendment that will help to future-proof the model in the event of changes in social and cultural circumstances that may lead to modification to the types of death and events the model may look to review in time. It also demonstrates my commitment to including so-called honour abuse within the model and ensures that this will be able to take place in the way that I believe that we all want. I would therefore ask committee members to support my Amendment 16 today, and I would also reiterate my offer to discuss so-called honour killings further with Ms Dowie and ask that she does not press her amendments in this group. Thank you.
Secretary, so if no other member wishes to come in, Sharon Dowie to wind up and press or withdraw Amendment 60.
Thank you. I appreciate the comments from the Cabinet Secretary, and I'll withdraw 60.
Thank you very much. So the members indicated that they wish to withdraw the amendment. Does the committee have any objections? No? Okay, thank you very much. So we now move on to our next grouping, which is Part 2 reviews linked to domestic abuse. And I call Amendment 14 in the name of the Cabinet Secretary, grouped with Amendments 15, 17 and 18. Cabinet Secretary to move Amendment 14 and speak to all the amendments in the group.
Thanks, Convener. The amendments in this group address the points raised by the Crown Office and the committee themselves during Stage 1 proceedings and address the request for reassurance that there is nothing contained within the bill which undermines the commonly understood definition of domestic abuse in Scotland. Amendment 14 provides that children killed by a parent where there was not domestic abuse or it was not believed that there was domestic abuse would not be included within the domestic homicide and suicide review model. It does this by requiring there to have been or appear to have been domestic abuse between the perpetrator and a current or former partner before the death can be a reviewable death. This ensures that abusive behaviour is out of scope of a domestic homicide and suicide review where it is not anchored in domestic abuse between partners or ex-partners. To clarify, this does not create or leave a gap in respect of deaths of minors, as cases that are, for instance, purely child abuse related would continue to be reviewed as they currently are through existing child protection learning reviews. With similar reasoning, Amendment 14 also provides that a suicide will only be reviewable where it is thought to have been contributed to by abuse from the deceased's partner or ex-partner. This means that children bereaved by domestic homicide or suicide who then die by suicide, or children who die by suicide where their parent was experiencing domestic abuse would not be included within the review model. These deaths where a child is a minor would continue to sit within the remit of child protection learning reviews, although these can be brought into the review scope in future through the enabling power within Section 10. Amendment 15 makes a consequential adjustment to the concept of a connected death of a young person. A connected death is where... yes.
Just on the definition point, I'm very grateful, and I think it's a good one, and I'm proposing to vote for it, but I'm just looking back at our report, and there were many witnesses who expressed concern about widening the definition, so I understand why this is being made. But there were witnesses who said, actually, look, we prefer the original definition as drafted, and gave various reasons for it. What does the Cabinet Secretary say to them? Because obviously their view is not the one that's being preferred here.
Yeah, and I mean, committee will recall that my initial position was that the purpose of the review is different from the prosecution of domestic abuse, that these are very clear, different, one's about holding perpetrators to account and one is about learning for the purposes of prevention. But, I have reflected on the committee's view as a whole in terms of your Stage 1 report. If things change in future, there is, of course, the enabling power within Section 10, but it's been, I suppose, a matter of fine judgment, but I think the overall view of committee and others was that we need to anchor this in our gold standard domestic abuse definitions. Convener, Amendment 15 makes a consequential adjustment to the concept of a connected death of a young person. A connected death is where the young person is killed in an attack on another primary victim. This amendment provides that where the primary victim has survived, the connected death is reviewable only if the primary victim's death would have been reviewable. So if this would not have been the case because there was no context of partner domestic abuse, then the connected death would also be out with scope. Amendment 17 adjusts the SIFT criteria in line with the changes in scope so that the Review Oversight Committee is tasked with considering whether and to what extent there is any link between partner domestic abuse and the death. This will also sift out cases where there is some history of domestic abuse, but this is not linked in any way to the death of the victim. This will involve an exercise of judgment based on all the facts and circumstances, so it's not possible for the initial notification stage. Amendment 18 is a minor technical amendment to correct the terminology used in section 16(3)(a) to match the rest of the section, and I move Amendment 14.
Thank you very much indeed. So if no other member wishes to come in, Cabinet Secretary, to wind up with any further comments?
No further comments.
Thank you very much. So the question is that Amendment 14 be agreed to. Are we all agreed? Agreed. Thank you. So I call Amendment 15 in the name of the Cabinet Secretary, already debated with Amendment 14. Cabinet Secretary to move formally.
Moved.
So the question is that Amendment 15 be agreed to. Are we all agreed? Yes. Thank you. I call Amendment 61 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
The question is that Section 9 be agreed to. Are we all agreed? I call Amendment 62 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
So I call Amendment 63 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
I call Amendment 64 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
I call Amendment 65 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
I call Amendment 66 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
I call Amendment 16 in the name of the Cabinet Secretary, already debated with Amendment 60. Cabinet Secretary to move formally.
Moved.
Question is that Amendment 16 be agreed to. Are we all agreed? Okay. And the question is that Section 10 be agreed. Are we all agreed? Okay. I call Amendment 67 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
I call Amendment 68 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
The question is that Section 11 be agreed to. Are we all agreed? Agreed. Okay. I call Amendment 69 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
So the question is that Section 12 be agreed to. Are we all agreed? Okay. And the question is that Section 13 be agreed to. Are we all agreed? Agreed. Okay. And the question is that the schedule be agreed to. Are we all agreed? Agreed. Okay. I call Amendment 70 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
The question is that Section 14 be agreed to. Are we all agreed? Agreed. Okay. Question is that Section 15 be agreed to. Are we all agreed? Agreed. Okay. So I call Amendment 71 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
I call Amendment 72 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
I call Amendment 73 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
I call Amendment 17 in the name of the Cabinet Secretary, already debated with Amendment 14. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 17 be agreed to. Are we all agreed? Yes. Okay. Call Amendment 18 in the name of the Cabinet Secretary, already debated with Amendment 14. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 18 be agreed to. Are we all agreed? Yes. Okay. I call Amendment 74 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move.
Not moved.
I call Amendment 75 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move.
Not moved.
And the question is that Section 16 be agreed to. Are we all agreed? Agreed. Thank you. I call Amendment 19 in the name of the Cabinet Secretary, already debated with Amendment 12. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 19 be agreed to. Are we all agreed?
Yes.
Thank you. I call Amendment 76 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move.
Not moved.
Okay, thank you. Okay, so we move to our next grouping, which is Part 2 reviews, notification of next of kin. And I call Amendment 77 in the name of Sharon Dowie, grouped with Amendment 92. Sharon Dowie to move Amendment 77 and speak to both amendments in the group.
Okay. My Amendment 77 requires the Review Oversight Committee to notify a family member who is the next of kin to the victim when a domestic homicide or suicide review is being carried out. The new Section 17(1)(b) would define family member who is next of kin as either a sibling, parent or step-parent, grandparent, child or stepchild, a guardian, and in order to reflect that all families are different, any other such person the Scottish Ministers may prescribe in regulations. My Amendment 92 is consequential to Amendment 77. My Amendment 77 aims to ensure the victim's family is aware of the review and that there is sufficient communication throughout the review process. The committee heard in its evidence sessions that it is important to communicate with the family throughout. In recent discussions with Victim Support Scotland, the organisation also highlighted the importance of communicating with the family at each stage of the review process. My Amendment 77 helps to ensure this. Amendment 77 introduces Section 17(1)(b) defining a next of kin family member. This aims to ensure that when notifying families of a review, this is not overly burdensome on the committee, as they are only required to notify a single next of kin. Amendment 77 also leaves it open to the Scottish Ministers to include other family members if needed beyond the immediate family. Thank you.
Thank you very much. If no other member wishes to come in, Cabinet Secretary.
Convener, family is an integral part of the review model and therefore I can very much appreciate the rationale for Ms Dowie bringing forward Amendments 77 and 92. However, the amendments in their current form are problematic for a number of reasons. Firstly, the next of kin in the context of domestic homicide or suicide is often the perpetrator, and while the amendments would allow the Review Oversight Committee to select which particular family member was contacted, and I appreciate that partners and ex-partners are not on the list in Amendment 77, that list is not exhaustive. In cases where the only family member was the perpetrator, the committee would be obliged to notify them. Or, if no other family members could be located, there would still be a statutory duty to notify, which the Oversight Committee would be unable to fulfil. A further risk in the Oversight Committee attempting to fulfil its duties would be where the committee contacts a family member who is not appropriate. I've said that it is my intention to include so-called honour killings within the review model once the necessary work to define what this means in Scotland has concluded, both from a policy and a legal perspective. As I said earlier, in cases of honour killings, there are often multiple perpetrators of honour abuse within the family, extended family and community. Therefore, where there is a duty to notify in such cases, it may not be clear who is the appropriate person to notify. While not currently required by the bill, it was always expected that the Review Oversight Committee would take all reasonable steps to contact relevant persons to make them aware that a review would be undertaken. The intention is to set out further detail within the statutory guidance using the existing power in the bill to ensure that this happens. This would provide more flexibility to take a considered approach to the circumstances of the case and to determine who, if anyone, is to be notified. I would hope that these comments about the use of guidance are sufficient to reassure Ms Dowie that nothing more is needed on this front. However, if she remains concerned, I would be happy to discuss this with her further and, if appropriate, work with her to bring back an amendment at stage 3 that would achieve the aspiration of the current amendments whilst ensuring it is sufficiently flexible to be able to adapt to the wide-ranging considerations that all need to be taken into account in relation to family and next of kin within the context of domestic abuse, homicide and suicide reviews. On that basis, I would ask Ms Dowie not to press these amendments.
Thank you, Cabinet Secretary. So Sharon Dowie to wind up and press or withdraw Amendment 77.
Thank you. Given the issues that were raised by the Cabinet Secretary, I would appreciate working with her towards stage 3, but I will withdraw the amendment. Thank you.
Okay, thank you very much. So the members indicated that they wish to withdraw the amendment. Does the committee have any objection? No. Okay, thank you very much. So we now move on to our next grouping, which is Part 2 reviews, minor and technical. And I call Amendment 20 in the name of the Cabinet Secretary, grouped with Amendment 30. Cabinet Secretary to move Amendment 20 and speak to both amendments in the group.
Convener, there are 2 government amendments in this group, both of which are minor technical amendments to provide clarity. In relation to Amendment 20, this would replace the word joint in Section 17(2)(a) of the bill with the word combined when referring to a review of 2 or more deaths. This is to avoid confusion as to what is meant by a joint review. The bill, as introduced, states that a joint review is a review of more than one death. However, stakeholders have adopted the term joint review to refer to a review that is carried out together with another type of review, for instance, a domestic homicide review and a child protection learning review. The amendment therefore looks to replace the term joint with combined to allow the term joint review to continue to be used as stakeholders are using it presently and to avoid any confusion. The second amendment in the group is Amendment 30, which again is minor technical amendment. The amendment is in relation to who must have regard under Section 25 of the bill to guidance issued by the Scottish Ministers. The amendment ensures that there is no doubt that references to their functions means the functions of the Review Oversight Committee and Case Review Panels, although this is how the provision would likely have been understood. This amendment puts it beyond doubt, and I move Amendment 20.
Thank you very much. If no other member wishes to come in, Cabinet Secretary wind up with any further comments?
No further comments.
Thank you. So the question is that Amendment 20 be agreed. Are we all agreed? Thank you. I call Amendment 78 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
So moved.
Call Amendment 21 in the name of the Cabinet Secretary, already debated with Amendment 12. Cabinet Secretary to move formally.
Formally move.
So the question is that Amendment 21 be agreed. Are we all agreed? Yes. Thank you. Call Amendment 79 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
So the question is that Section 17 be agreed to. Are we all agreed? Yes. Okay. So I call Amendment 80 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
Okay, so we move on to our next grouping, which is Part 2 reviews, interaction with inquiries. And I call Amendment 22 in the name of the Cabinet Secretary, grouped with Amendments 23, 24, 25 and 26. Cabinet Secretary to move Amendment 22 and speak to all amendments in the group.
Convener, Amendments 22 to 26 in my name relate to an operational matter with regard to domestic homicide and suicide reviews. As introduced, the bill makes provision for the Lord Advocate to be able to order the suspension of consideration of a death or a domestic homicide or suicide review for such period as appears to the Lord Advocate to be necessary to allow for the completion of any other investigation or the determination of any criminal proceedings or a fatal accident inquiry. There is a similar power for the Lord Advocate to be able to discontinue the review altogether. These amendments extend these powers of the Lord Advocate to also cover an inquiry under the Inquiries Act 2005, for which the Scottish Ministers are solely responsible. This will ensure that where a public inquiry is examining a death, perhaps as an alternative to a fatal accident inquiry, the Lord Advocate's powers can also be used in relation to such an inquiry in the same way as it could in relation to an FEI. Prior to introduction of the bill, we sought the views of the UK Government on whether similar provision was necessary in relation to public inquiries established by them. The UK Government stated that such instances would be rare, and they do not consider that in such instances a domestic homicide or suicide review in Scotland would need to pause or stop. Therefore, my amendment expands this in respect of Scottish inquiries only. The bill also makes provision in Section 19 for a protocol to be developed and agreed between the Scottish Ministers, the Chair of the Review Oversight Committee, the Lord Advocate and the Chief Constable, on how these new reviews will interact with other proceedings together. These protections are to avoid prejudice to criminal investigations proceeding or an FEI. Amendment 26 will now expand the protocol to include public inquiries for which the Scottish Ministers are solely responsible as a consequence of Section 18 being expanded by Amendments 22 to 25, and I move Amendment 22.
Thank you very much. So if no other member wishes to come in, Cabinet Secretary to wind up with any further comments?
No further remarks.
Thank you. So the question is that Amendment 22 be agreed to. Are we all agreed? Yes. Thank you. I call Amendment 81 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
I call Amendment 23 in the name of the Cabinet Secretary, already debated with Amendment 22. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 23 be agreed to. Are we all agreed? Yes. I call Amendment 82 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
I call Amendment 24 in the name of the Cabinet Secretary, already debated with Amendment 22. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 24 be agreed to. Are we all agreed? Yes. I call Amendment 25 in the name of the Cabinet Secretary, already debated with Amendment 22. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 25 be agreed to. Are we all agreed? Yes. The question is that Section 18 be agreed to. Are we all agreed? Agreed. Thank you. I call Amendment 83 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
I call Amendment 26 in the name of the Cabinet Secretary, already debated with Amendment 22. Cabinet Secretary to move formally.
Moved.
The question is that Amendment 26 be agreed to. Are we all agreed? Yes. Thank you. The question is that Section 19 be agreed to. Are we all agreed? Yes. I call Amendment 84 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
I call Amendment 85 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
So the question is that Section 20 be agreed to. Are we all agreed? Yes. And the question is that Section 21 be agreed to. Are we all agreed? Yes. Thank you. I call Amendment 86 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie to move or not move?
Not moved.
Okay, thank you. So we move on to our next grouping, which is Part 2 Reviews, Case Reports. And I call Amendment 27 in the name of the Cabinet Secretary, grouped with Amendments 28, 29, 31 and 32. And I point out that if Amendment 31 is agreed to, I cannot call Amendment 91, which was in the group Part 2 Reviews, Familial Homicide and Honour Killing, due to preemption. So, Cabinet Secretary to move Amendment 27 and speak to all the amendments in the group.
Convener, the following amendments seek to strengthen what is to be included within case review reports, with a further amendment to include a dispute resolution mechanism within the model. Amendment 27 makes a change to require a case report where the case is about partners or ex-partners to include an analysis of the social connections of the victim and perpetrator in the lead up to the death. This should include the strength of those connections, whether they were strong or perhaps fractured or strained, and any changes in those relationships prior to the death. Such connections would include friends, family, work colleagues and relevant others. This change reinforces the importance of safeguarding those who experience domestic abuse. This will help to identify risk factors which have not previously been considered. The absence of such a requirement has been identified through recent research of domestic homicide cases, and without this being included, potential risk factors could be missed. This provision will ensure that this is a feature within the case review reports. The purpose of Amendment 28 is to broaden the scope of Section 22 of the Bill to include recording instances of good practice. Currently, there is provision in the Bill requiring case review reports to include where there are lessons to be learned from missed opportunities to safeguard those affected by abusive domestic behaviour and promote the well-being of victims of abusive domestic behaviour. This change will ensure that lessons can also be learnt and shared from identifying and outlining good practice, in addition to helping to reduce any defensiveness from agencies participating in a review. Requiring good practice to also be reported will strengthen the review process. The amendment will demonstrate a focus on openness to learning, not blame, and emphasise that there are positives that are important to learn from too. In relation to both amendments, it would be possible for the report to include these things just now, as the bill is not exhaustive as to what a report must include. However, these issues are felt to be sufficiently important that steps should be taken in primary legislation to ensure that they are considered in every instance. Convener, I will now move on to Amendment 29, which addresses a slight potential gap in the bill in the event that a dispute between the Review Oversight Committee and a chair of a case review panel cannot be resolved. This would most likely be where the panel chair has submitted a case review report to the Oversight Committee and the chair does not agree with a direction made by the committee to resubmit that report with changes. I anticipate that in such an event, the committee and the panel chair will usually be fully capable of resolving any disputes through dialogue, and it is unlikely a mechanism will be needed. However, in the event that this cannot be achieved, then there is not currently a process to resolve these matters. This amendment therefore ensures a mechanism is in place if needed. The risk in not having a dispute resolution mechanism available include delay in signing off and publishing a case review report, which would obviously negatively impact on bereaved families. A further risk is that where there is no route to resolve disputes about changes to reports, this could lead to case review chairs stepping down. This would also be problematic for bereaved families, as a panel chair may well be undertaking more than one review at the same time. A rapport with bereaved family members would need to then be established by a new chair. To prevent such risks, Amendment 29 introduces a regulation-making power which would be subject to the affirmative procedure under Amendments 31 and 32 to enable disputes to be resolved. The resolution could either be provided by the Scottish Ministers directly or through the Scottish Ministers appointing an appropriate person. As I mentioned, it is anticipated that if there are disputes between the Oversight Committee and the panel review chairs, these will normally be able to be resolved through discussion, which the amendment also accounts for. However, I believe it is necessary to ensure the bill includes a mechanism to facilitate the resolution of such disputes should it be required, and I move Amendment 27.
Thank you very much, Cabinet Secretary. So if no other member wishes to come in, Cabinet Secretary, to wind up with any further comments?
No further remarks.
Thank you very much. So the question is that Amendment 27 be agreed to. Are we all agreed?
Yes.
Thank you. I call Amendment 28 in the name of the Cabinet Secretary, already debated with Amendment 27. Cabinet Secretary, to move formally.
Moved.
And the question is that Amendment 28 be agreed to. Are we all agreed?
Yes.
Thank you. I call Amendment 87 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie, to move or not move?
Not moved.
Thank you. I call Amendment 88 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie, to move or not move?
Not moved.
Thank you. I call Amendment 29 in the name of the Cabinet Secretary, already debated with Amendment 27. Cabinet Secretary, to move formally.
Moved.
Thank you. So the question is that Amendment 29 be agreed to. Are we all agreed?
Yes.
Okay. I call Amendment 89 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie, to move or not move?
Not moved.
So the question is that Section 22 be agreed to. Are we all agreed?
Agreed.
Thank you. The question is that Section 23 be agreed to. Are we all agreed?
Yes.
Thank you. So I call Amendment 90 in the name of Sharon Dowie, already debated with Amendment 60. Sharon Dowie, to move or not move?
Not moved.
And the question is that Section 24 be agreed to. Are we all agreed?
Yes.
I call Amendment 30 in the name of the Cabinet Secretary, already debated with Amendment 20. Cabinet Secretary, to move formally.
Moved.
The question is that Amendment 30 be agreed to. Are we all agreed?
Yes.
And the question is that Section 25 be agreed to. Are we all agreed?
Yes.
Thank you. I call Amendment 31 in the name of the Cabinet Secretary, already debated with Amendment 27. And I remind members that if Amendment 31 is agreed to, I cannot call Amendment 91 due to preemption. So, Cabinet Secretary, to move formally.
Moved.
Thank you. So, the question is that Amendment 31 be agreed to. Are we all agreed?
Yes.
Thank you. So, I call Amendment 32 in the name of the Cabinet Secretary, already debated with Amendment 27. Cabinet Secretary, to move formally.
Moved.
Thank you. The question is that Amendment 32 be agreed to. Are we all agreed? Thank you. I call Amendment 92 in the name of Sharon Dowie, already debated with Amendment 77. Sharon Dowie, to move or not move?
Not moved.
Thank you. So the question is that Section 26 be agreed to. Are we all agreed?
Yes.
Thank you. The question is that Sections 27 to 29 be agreed to. Are we all agreed?
Yes.
And the question is that the long title be agreed to. Are we all agreed?
Agreed.
Thank you very much. And that ends Stage 2 consideration of the bill. So we've now completed our Stage 2 consideration. I want to thank everyone for the constructive way that they have engaged with the debate and for our collective endeavours. And I also wish to thank the Cabinet Secretary and all her officials for their contributions. So we will not be meeting next week, as a committee will be visiting HMP Edinburgh as part of our inquiry into reducing harm from substance misuse in Scottish prisons. And on that, I now close the meeting. Thank you.